them, involve them, get a solution to this matter in at most a month, and I think that is also doable.
Okay. Thank you very, very much, Your Honor. I will now request the Commissioner Honorable Acting CJ to ask you further questions.
I thank you. My Lord, let us look at ourselves from within so that we can say where my Lord will take us next. We have an instrument called the SJT, which is our current blueprint. At every page of it, we emphasize bottom-up approaches, strategies, and purpose-driven leadership. That is done with an intention to achieve for ourselves an agile, modern, and responsive judiciary. My Lord, with particular emphasis on our subordinate courts, please give us your conception of purpose-driven leadership, how that can be engendered in our courts, and more particularly, the subordinate courts and the tribunals. Please be specific to the area that I have directed my Lord to.
Purpose-driven transformation or systems of getting results intend or would focus on where you have identified what you want to get. The main product we have here is output, dealing with the matters that we have in the magistrates' courts, in the tribunals. So what we would require to do is educate everybody of their place, and within themselves form leadership circles, so that these people are educated on their targets, what we require to achieve from their work. These people are guided on how to do this, lead themselves to achieve the set goals. These people are shown and monitored so that they are able to do that on themselves. We would have supervision from other sectors, but within themselves, this should be emphasized so that we have internalized the leadership in the tribunals. We have internalized the leadership in those so-called subordinate courts. They become their own masters, and they are capable. The differential between those who are in the magistrates' courts, in the tribunals, could be a differential of age. They are trainees, professionals like us. In so little time, they will be our age, and they are dealing with the bigger things. So motivate them, educate them, train them, and give them the steps of leadership, the methodology, etc. When they are educated, when they are trained, when they are shown the way, you lead by example, you demonstrate.
My Lord, may I? Is
Please.
that to suggest that all the things my Lord is talking about now are not in place? That the people we have in the subordinate courts, which is actually our highest constituency, are not equipped in the manner my Lord is suggesting?
I am not suggesting that. I've been to various courts. I've served in various stations. In fact, I'm a Kenyan. Even without being in the judiciary, I would know that they do that. But now we are talking about result-driven leadership. where you emphasize and you do your targets. These people are, are educated. They are shown the importance, because we may have issues now because of things like laxity, things like lack of firmness, things like lack of knowledge. So re-engineer this system, motivate these people, and I believe motivation would go a long way in getting them to do things faster, better, and achieve bigger results. We have them agreed, but we require that they are motivated, they are monitored, they are educated, they are loved.
Thank you, my Lord.
And
thank you.
Thereby we achieve what we wish to do.
Thank you.
Yes.
Ours could be described as an extremely unique institution where judicial officers, who include judges, have some special protection called independence. But my Lord appreciates that independence does not stand alone. Would my Lord please tell us what it stands with, and how, as our team leader, my Lord would foster that independence with that other something that I would like my Lord to tell us what it is on the judicial and the administrative function of my Lord, the Chief Justice.
Thank you, my Lord. The history of this of the judiciary has a situation that the issue of independence of the judiciary was overplayed, such that when performance contracting came in some maybe 10 or 20 years ago, it was resisted so badly. We have come to learn that we are accountable, and accountability is a part of our system and our agenda. So we cannot run away from accountability on the pretext of independence. We have an employer. This employer has invested in us, and he must get results. In the first, transformation framework, we laid the grounds for transformation, and this was effective. So in the second phase of the transformation, we had the SJT sustaining the transformation. In this transformation, we put in measures like performance contracting, where every person in the judiciary would be gauged on what he produces. This is accountability, on grounds of accountability, and accountability becomes part and parcel of what we must always emphasize, so that at the end of the day, today, we know what judge so and so has done. We know what officer so and so has done. We are able to tell Kenya, or the people, our employer, that this is what we are doing, this is what we have achieved. We have not achieved any better because of A, B, C, D, and E, and therefore, we are accountable to our employer. Kenya must reap results for investment. I have never doubted that, and I would sit in and ensure that every staff of the judiciary, judicial officer included, is accountable. You are able to tell us, this is my bag of goodies I have packed for Kenya.
I thank you, my Lord. There is something we've been doing since 2018, and it is called reorganizing ourselves. The organization review. Would my Lord please discuss what we are doing there, with particular emphasis on the objectives of the reorganization towards enhanced service delivery?
I am not an insider in that kind of...
Yes, my Lord, you are. an insider. Would you please discuss that matter? My Lord has been here since 2012, right?
Please repeat the question.
Since 2018, this institution of yours and mine has been undertaking a reorganization review with a view to enhancing service delivery. My Lord, the question we ask is, what have we been doing? Is it achieving the intended purpose? And now that you ask that, I repeat the question. I'll add a rider to it, what my Lord is doing about it.
Service delivery is a must for all of us, and we must do the delivery in an adequate manner. What we have done is an enhancement of resources so that we are able to enhance, to facilitate our staff to deliver. We have also come in with an effective, system of monitoring delivery of service. We are able to monitor performance through the DCRT, through the monthly returns, etc. What we are saying is that we put in place facilities, or we put in place systems which would make us do better in terms of service delivery. We put in trainings which would make our staff, particularly at the level of down there, the support staff, be able to facilitate those who are judicial officers or those who are up there to perform. So I cannot complain. We have done so well insofar as the delivery of service is concerned. We are able to issue our returns on a daily basis. We are able to record our judgments through Kenya law.
Let's do this, my Lord, if you allow me.
Please.
As my Lord the Chief Justice,
yes,
if God allows that to happen, then you become our team leader.
Yes.
This reorganization starts from the top and goes to the bottom. Remember, my first question was on our bottom-up strategies. How would my Lord the Chief Justice ensure that each one of us in this institution is with everything we are doing?
Firstly, it will require training. Secondly, it will require effective leadership, so that at all levels we have supervisors who are able to get everybody on board. We don't have any loose ends, so that people are just scrambling over nothing. They do not know what they are doing. So leadership is very, very effective. 2, education through training would be another factor which would facilitate this kind of thing. And like you said, bottom-up approach, so that everybody becomes a leader. We are able to get things moving up and moving down, so that the two approaches, bottom-up and up-bottom, become effective, and thereby we get what we want.
All right, my Lord.
Involve all the stakeholders, involve our staff, so that they become partners in what we are doing.
Thank you, my Lord. Let me first ask a direct question.
Please do.
And then we can have a discussion thereafter. What is our current strategic plan cover? What period does it cover?
I am not aware of that one.
Which means then that my Lord would not know the strategies, particularly the policies that are discussed in the current policy?
I would not.
Thank you, my Lord. Let's go to the next issue, which is this, and flows actually from the first part. you do not have to be aware of what we have put in the current strategic plan for my Lord to know, because you have been heading stations, at least 2, Kericho and now Nyeri, to know what administrative gaps we have in the institution. And you, my Lord, if God allows that you be the CJ, you are the person to fill those gaps, with us behind you, of course. But being the team leader, remember, if those of us behind my Lord become too kajuaji, so as I think Kiswahili is part of our national language, we couldn't lead you. You would have to lead us. And then we follow with ideas, we give you our suggestions, which you may or may not accept. So what are those administrative gaps in particular that my Lord would want to see covered, filled, so that we move this institution to the next level?
One, we would require to streamline administrative structures insofar as judicial performance is concerned. What we have now is, for example, in terms of a high court station, is a judge who is presiding, and maybe other judges who are his followers, her followers. In terms of administration, we have everybody in every other sector, HR, ICT, etc., etc. So what we would require to factor in is that every sector, firstly, has people who are qualified, people who are experts in that line. What we have now is, for example, in HR, is directories which are regional. It may be necessary that in the future we have people in every station so that they can be able to address the feelings of the people, the issues of the people in that station. ICT, we have people, particularly now that we are on teams and we will require them. We have people in every station, but sometimes they are not adequate. Like in Nyeri, I see our officer who is at the headquarters, rotating everywhere to
so
go and
resolve the first
issues.
one would be to deal with the human resource issues. The next one would be?
Issues of, finance. Finance is a very, very critical in performance. We'd have to source funds and facilitate the activities of every other issue or every other matter that we want to partake. The third one would be, like I'm always saying, training of these people, coordinating them. Because one of our biggest issues in the public service, not necessarily even in the judiciary, is that people get disgruntled and you are not working with them. You are there, they come in the morning, they leave in the evening, 3 years, they are away, etc., and nothing happens. So how do you monitor this? I started with saying that we should be able to monitor our people, we should be able to motivate them, we should be able to buy them, buy our staff to our side through incentives which are available, and be friends with our staff. That is the biggest resource. Any other factors, finance included, will not make a difference without an allegiance by our members of staff. And when we achieve that, all these other factors come into place. So buy your people, put them in place, motivate them, make them happy. When you make them happy, everything will happen. When you involve finance and resources, when you facilitate them, they'll be able to do what they must do. When you train them, when you streamline the governance patterns, like in the case of, I mentioned the case of the chief magistrate, who is the CEO for every station, the magistrate in charge, the judges there with a presiding judge. You create specific roles so that these officers become accountable. Accounting becomes a parameter for performance and for your job and your profession, so that we are able to serve and do Kenya good.
Thank you, my Lord. My Lord, as Chief Justice, would be the chair of the National Council for Law Reporting. What are the functions of the National Council for Law Reporting?
We start with the law reporting. It's one of the major functions of the council. The other one is transacting with our judicial officers so that they are on the know by way of information on emerging jurisprudence, the case-back system, and other factors like that. When we have a crowd moving a case, it is their duty to broadcast it, to make it known to those who are consumers of that kind of precedent. The law reporting would also be tasked, or is tasked with the duty of streamlining law reporting and doing a highlight insofar as the performance of the judiciary is concerned. You remember we said we send our course list to them for broadcast nationally. So it is their duty. It is their duty about to broadcast the judiciary and our techniques for performance, the DCRT, etc., to the Kenyan public for purposes of accountability. In that reporting, they are highlighting what we are doing. They are highlighting performance. They are highlighting our daily cues. And thereby, we move on and get them to work to achieve those desired results.
Thank you, my Lord. Maybe you could tell us where the National Council of Law Reporting is resident. In what institution is the National Council for Law Reporting?
Their residence is at Milimani Law Courts, Milimani Commercial Courts. That is the one.
Sorry, my Lord. Under whom?
It is under the judiciary.
It is?
It is a parastatal within the judiciary.
Let's discuss this because I think it's important. The law reporting, you and I, my Lord, will agree, is an important aspect of the work we do.
No doubt, my Lord.
As we speak today, it is resident in the office of the Attorney General. It used to be resident here, but it moved.
I am not aware of that one.
Which means my Lord would not know the reasons why it moved and whether, in fact, that movement was right, whether they should stay there or whether the person they serve isn't the Kenyan public through the judiciary of Kenya.
No doubt, the National Council for Law Reporting serves the Kenyan public. It is funded by the Kenyan public, and all its issues and concerns pertain to the welfare of Kenya. That being the case, I think the departure from is the most direct link, which is the judiciary of the Republic of Kenya, and which would require it more because of the linkages to the other ministry, the Office of the Attorney General, must have been some administrative measure. It was a government planning, like we said from the beginning. We are complementary. So if there are any issues which relate to this and which the judiciary feels are not in tandem with its good feelings or with its systems, the way out is to renegotiate.
My Lord, to be fair to all of us,
yes,
my Lord confessed that he does not even know where they are resident, and therefore my Lord would not know the reasons why they moved. And I think we shouldn't continue to discuss that in abstract. We would have to get the real reasons to know why exactly it moved, whether that movement wasn't the right thing, because you could disagree with any statement I make or anybody else makes. But let's make progress here. Chief Justice Mutunga was JTF. Chief Justice Maraga was SJT. Chief Justice Marete would be?
Mine would be to practicate judiciary transformation. Why would I do that? We are 9 years down the line. The first one was 2012 to 2016. The other one was 2016 to 2021. That is a cumulative 9 years. We cannot go on transforming forever. We should have transformed. So what happens in the circumstances? I learned in the office of the Chief Justice, and first thing I do an evaluation. I cause an evaluation of how far we've gone in the first compartment, Emeritus Chief Justice Mutunga's JTF, Judiciary Transformation Framework, which was merely, basically laying the background. We come to the one for Emeritus David K. Maraga, and we assess now and get an assessment of how far we are insofar as judiciary transformation is concerned. When we are through with that report, it will tell us how to get moving. And my take in this one would be, if we are not through with that, with the transformation, the style of JTF, the style of SJT, then we give ourselves strategies to deal with this, but do a practication, because we have this, down. It has been done, it has been started. We now know the percentage of a transformation that we had. So now, practicate this, make it real. How would I do that? I have talked about two stakeholders, the judiciary staff and the Kenyan public. With those two stakeholders happy, if you make the judiciary staff happy, if you make the Kenyan public happy with you, you've been good stead to practicate, because that is number one. If you achieve that, everybody who comes through the corridors of the judiciary leaves happy. This is costless.
All right, my lord. Let's go to something else. And it is this. I noticed from your papers that you have a diploma in theology from the PCA University.
Yes.
And now, from that, I ask this question.
Please do.
How do you relate your moral opinions with your judicial philosophy? Would you associate with the legal theories that emphasize an intersection between the law and morality?
I have done my fair share of jurisprudence. How would I relate who I am as a Christian? Because I have many faces. I'm not merely a Christian. I have my other facets and personalities and persons. So the issue is Christianity vis-a-vis what I do. One, I have come to the judiciary. I am an employee of the jails.
I'm glad you are a Christian. You're in good company. I am a Christian. I like to think I'm a fairly good Roman Catholic. But one does not have to be a Christian to do theology. One doesn't have to be. One doesn't have to be a Christian to do a diploma in theology.
Yes.
And so the question is, having done that diploma in theology, how has it prepared you for the work you do? And do you mix theology, religion, morality, and the law?
One, as an officer, like I was saying, I am an employee of the judiciary. Who I am as a Christian is separated from this. Agreed, the School of Law called, the Realist School of Law, says that, states that, opines that a judicial officer would largely, what you see in a judicial officer, or the product of a judicial officer is who he is in terms of personality, in terms of ideology, in terms of thinking. Good enough. That is a legal theory, and we leave it at that. What do we deal with here on a daily basis? You remember my personality, myself, and my Christianity serve me as such. It's a spectrum of my life which is complete and whole. But I must be able to relate this very, very carefully and cautiously with what I do in other spheres of my life, such that when I come to a place like this one where I have to make a decision, it can guide me, no doubt, because even if you are not a Christian, there is some element of religion in everybody, including African traditional religion, which I suspect is almost dead now with 140 years of colonialism and post-colonialism. Africa's culture and religions are almost dying. So we are saying that we must be able to separate and draw a distinction between the diploma in theology and your religious faith and what you do. You can relate it to some extent, but to the extent that is palatable and acceptable, not anything beyond that. We were not called upon to come to the judiciary to preach, whatsoever not. We were called upon to the judiciary to come and do that which we are assigned, and do it in decency.
Thank you. If you find a lacuna in law, what would my Lord do?
One, before you make a decision and it is broadcasted, there is the issue of a consultation. You discuss to identify whether indeed what you are seeing is a reality. When you find a lacuna and it is established that it is one,
and you are in the middle of a hearing, my Lord, and you must make a decision in that matter, and my Lord encounters what appears to be a lacuna in the law, what would my Lord do?
You address that.
By what
At
means?
the hearing, if you can, you point it out to the other participants, the litigants, and you look for a middle ground. When you sit down to do your write-up, the ruling or judgment, you would have to point that out. Like I said earlier, this would require consultation amongst your colleagues, so that at the end of the day, you do not, address yourself. You do not clear the lacuna. You do not create your own law and apply it No. You just note that in the process of hearing etc., I found out that there is this gap, and you could even point it out to Parliament. Is a stakeholder. I would point it out to Parliament and say, this is what I observe. But when you are very, very clear that what you are doing makes sense, when you've consulted adequately throughout your colleagues and agreed that it is an issue which requires address at any other forum. Yes.
I want us to get to the Supreme Court, but before we get there, let me just read you this quote from Dawkins, and he says, there can be no gap in the law. The law is more than rules. It is also about non-rule standards, so that my Lord could reflect on that later. But let's get to my Lord's role as the President of the Supreme Court. My Lord arrives in May and finds 5 of us there already, and my Lord comes with one other judge. My Lord has primarily sat as a single judge, primarily. But when my Lord arrives, finds that this court of necessity sees as a multiple judge court. The bench must have at least a minimum of 5, okay?
Yes.
Is that an easy thing to do? Is sitting in 5 easy?
It is not.
Why is it not
particularly
easy?
for the likes of us who have not even had an occasion to sit as 2 or 3. But the argument is countered by the fact that from day one, 16th of October 1980, when we entered the law school up here, we've had interactions with this kind of situations. We've learned, we know. The only thing is that the only difference is that we've not encountered that. 2, we are equal to the task. We can learn. By the time we leave that evening, I'll pick from yourself, the Deputy Chief Justice, or even before we have a session in court, so that we are able to get educated, we are able to get the exposure, we are able to get
That's fine, my Lord. The question is, because I think this is important, let's just spend another 2 minutes on it.
Please.
Is it easy to sit in a multi-judge bench?
It will not be at any one time because of the issue of diversity. The issue of, like you are asking about, your tentacles insofar as religion is concerned, your ideology, your legal philosophy, etc. That diversity is supposed to be an asset, but can also be a liability in the sense that...
in fact, stop there. I'm glad you said an asset, because I want us to discuss that other side. Is it not a good thing to sit in a multi-judge bench, because then your idea is strengthened by the weaknesses or strengths of each of your partners on the bench?
It is good. And particularly,
so it's both good and bad?
I am not going to say it is bad. It has all pluses. The only difference and being a liability would come when these people, are not able to agree, and that is allowed. When this disagreement becomes like a part of the problem, and when this disagreement becomes a liability now, or becomes a fetter to the progress of decision-making in that court, at all times, this would be an asset. It would be good. There is diversity. There is an exchange of minds. There is, you are able to, interrogate issues and share in a good collegiality. But if this is not the case, if this becomes a problem, if there's no collegiality, if there's no maturity, if there's no tolerance, it becomes a problem, and we can have stalemates, and that will be extremely dangerous. That is not what Kenya has set us here for.
Yeah, but my lord, it's you who has set yourself up to become Chief Justice. And so you would be telling this commission that even though it is your first time you're going to do this, this is what has prepared you for it, and this is the arsenal. You have to get the 6 of us to work with my lord, the CJ.
Decision making is personal, but we have not even reached there. Day one, we have a matter. When I am new, I will not get to that matter before we have a meeting as the College of Judges in the Supreme Court, so that I am able to learn and know how these things, even the feel itself, that these are the 7 judges of the Court of Appeal, of the Supreme Court. We are sitting together, we are sharing. They are teaching me from the onset so that I become a part and parcel of their team. I would nurture that from the onset so that we don't have any sitting before that is done. And thereafter, we would sit. I would be able to appreciate the issues. I'll be able to relate even more. And in less than no time, in a month, 2 or 3, at most 4, we would be partners in progress, equals in the game.
All right. My final question, my lord.
Please do, and thank you.
What is your most favorite judgment from the Supreme Court, and why is it your most favorite? And I wish you very well, my lord.
I have had occasion to look at the digest which you issued some 2 or 3 years ago, and I looked at those judgments. The other day when I was preparing for this interview, I came across the Marete judgment. Even without looking at all the other matters on elections and references and everything else, let me come to Marete. Marete is a good judgment in the sense that it has brought us to, in tandem with the current constitutional requirements globally. Murder, death sentence, etc., etc. You talked about religion. I mean, at what time should anybody lose their lives? We are saying that we are on a platform of human rights. We are also agreed as judges and judicial officers. The profession is agreed that more often than not we are making mistakes. So when we do 10 murder cases and hang them, maybe 4 of them could be innocent. Circumstantial things just find them there, etc., etc. So for a long time, the death sentence has not been acceptable. The death sentence has been overtaken by events in other jurisdictions. So when the Supreme Court came up with a decision that that must be done away in this with in this country, I would say that was a ground breaking.
Thank you. So my lord likes Marete because the Supreme Court outlawed the death sentence.
Yes, Marete to us is...
Thank you very much, my lord.
Thank you, my lord.
Thank you, Chair.
I'm so glad that we had that occasion to tete-a-tete over one or two small things.
Thank you, brother. Thank you, my brother.
Welcome.
Okay, thank you very much, Your Honor. I will now request Judge Wasame to continue, and the commissioners will restrict ourselves to about 30 minutes or less. Thank you.
Okay, thank you, Chair. I'll be brief because my predecessor has almost asked almost all my questions. Judge, I will ask you 4 issues.
Please do, and thank you so much.
Yes, and 2 of them You are the one who raised them about the backlog and how you will resolve it. Now that you are applying to become the Chief Justice of the Republic of Kenya, you must be the leader. And there must be evidence in terms of your productivity that you have been a leader in that area. Isn't it?
Yes, sir.
I have a report from the performance and productivity of the Honorable Mr. Justice D.K. Njagi Marete for the period between 2016 to 2021.
We appreciate.
Yes. During that period, my Lord, it says that you handled 3,436 matters. Out of those matters you have handled, you have delivered 73 rulings. Those rulings did not also resolve the cases or close the cases.
Yes.
Again, you delivered 271 judgments. Is that a reflection of Chief Justice Marete?
No, it would be dastardly to have a Chief Justice of that caliber. But I'll go back and answer your question in this manner. In 2018, I was transferred from Kericho. And the ground of my transfer, although it is not stated, was that I had cleared everything that was supposed to clear about the Kericho station. Kericho had a balance of 50 or less files. Eldoret had 800 files. So I made a departure from Kericho to Eldoret and left it judgeless because it would not have been logical to put a judge there. I have my issues on this kind of report. 271 judges in 3 years. I doubt its accuracy because on average, Judge Marete at Kericho he was the sole judge in the station. And on average, Judge Marete would do about 20 judgments. So how would the 20, which is 240 judgments and rulings, on the lower side, how would 20 times 24 times 3 amount to 271 and 73? This is 300 or 350. I doubt that accuracy. Unless there are issues of not transmitting good returns, I'll clearly say with no doubt that is not an accurate report of my performance.
Okay.
And if I do, I would apologize and leave office.
Okay. So if we ask you, for example, to avail your statistics for the period between 2016 to 2021, which is not a reflection of what is before us today, you will be able to do that?
I'll do that with lots of ease. I'll get my dear at Kericho and it will be availed.
Okay. The second issue, my Lord, is an issue which you raised yourself about, you said you are a person living with a disability.
Yes, sir.
Is that correct?
It is correct. I am a person living with disability.
Okay. And before you are granted the certificate by the National Council for Persons with a Disability,
yes,
you must have been assessed.
I was assessed.
And
I've even been assessed just the other day in a renewal.
And that your request was approved from the minister downwards.
Yes.
And in your application, you indicated the nature of the disability which you are suffering from.
Yes.
Were you given a card?
I have a card.
You have a card?
It is here.
You have it there?
Yes.
I don't know, the card in your file reads, I don't know whether it is true, my Lord, and I apologize if it's not the correct card.
Yes.
It says name D.K. Njagi Marete. It indicates your registration number, and then it indicates the nature of disability, visual, mental. Is that a reflection of you?
I have a visual disability.
Yes.
Which has been with me for a long time.
No, I'm asking the second part, my lord.
No, that I have no mental issues. This was an error. I was warned about it by a colleague who is also, a person living with disability. I have never had time to have it addressed.
And this card was given to you, my lord, in 2015.
It was issued to me in 2015.
Yes.
I didn't realize that it was an error. I am diabetic.
No, I am not asking about that, my lord. When did you realize that there was a problem in your card, that there was the issue of mental?
I saw it from day one when the card was issued down there.
Yes.
I didn't think it was an issue because when I went to do my application to the director, persons with disability, I cited two issues. One, I have a visual issue. Two, I am diabetic, and occasionally I get affected by what we call low sugar issues, hypoglycemia. So when they looked at it, they dismissed the second issue as a case of disability. And that is where this error came in. From my record, which was in that original application, the issue of hypoglycemia, diabetic versus, oblique hypoglycemia, was taken or was translated to be mental disability, which will never be the case.
Okay, difficult question. I'm not a doctor. Again, my lord, since you joined the judiciary, you have also been having some personal issues with the registrar, with JSC, about your driver.
Yes.
And I have seen a letter from the principal judge of your court saying that the Honorable Mr. Justice D.K. Marete has been having problems with the drivers since 2014. The last one walked away this week. What is the problem with the drivers?
When we came into the judiciary in 2012, I opted to use drivers who were civilian, not police. There is a Mr. Mwangi whom I had employed myself, and I requested that be employed by the judiciary so that he serves me in the absence of a police driver. I am not able to deal with the police drivers in the sense that I have a very rigid schedule. I do not drive because of my health issues and also my choice. I am not a good driver. So I've always preferred that I have a civilian driver who is flexible and who is able to answer to my needs. So what happened is that my driver was employed in 2013 on contract. When I raised an issue on that one, I was told, good enough, we can let us watch him for 1 year. And when we do that, we'll be able to assess whether he's suitable and material for permanent employment or not. 1 year down the line, on 7th of September 2014, when I was going when I was on my way to Kericho, the contract for this driver, Mr. Peter Mwangi Moria, was terminated. Thereafter, I went on a negotiation mission. The CRJ and Chief Justice Motunga, and we agreed that I would restate Mr. Mwangi so that Mwangi would be paid, and then he does referred to me, and he remains and serves me. Mutunga left. That did not happen. I consulted the CRJ, and we had issues, and she told me that what we are going to do is wait for an opportunity and an advert and get Mwangi to apply so that we can formalize that employment. Well, I was not convinced, but that is not my area. I would not order what happens. So Chief Justice Maraga comes in, and the first week or month I go to see him over the same issue. And I do. And we agree with my Justice Maraga, the CRJ, that the CRJ looks into the matter. And all that time, from the 7th of September 2014, I have been paying my driver. In fact, Mwangi ultimately left in fury because I will not go to tell Mwangi that I am doing this matter for you. I'm negotiating with A, B, C, D, and E for you. That is not good, the best of practices. I was quiet. So we were there, and in year 4, he got tired and left. I got other people. Intermittently, police drivers would come in. So one lasted a day, another lasts a week. The best one lasted about 3 months, and they get very impatient and they take off. Reasons I will not be able to tell, but that is my matter with a driver. From 7th of September 2014, going to 6 years now, I have not had a driver who is supplied to me by the judiciary. I have paid my driver.
Okay. The second issue, you have been also having the issue of your personal aid, my lord. Is it a matter of concern to the commission?
It is a matter of concern, but when I become Chief Justice and come to Nairobi, it will not be an issue anymore. Why? My issue of hypoglycemia is an issue, a medical issue, which everybody should pay attention to. I cannot live alone whatsoever. So when you take me to Kericho, we have a home in Nairobi and a home at Chuka. When you take me to Kericho, my spouse must accompany me. When I take any safari or any venture for the judiciary, for my employer, which is out of my station, she must accompany me on grounds which are medical. Thank God we will be Chief Justice in so little time. And when we come to Nairobi, we shall not require any of those issues because we shall be home. The issue was when we served outside Nairobi, we will never serve Chuka. It will not work. So if you send us to Chuka and we are there and you agree that we should be at Chuka, we shall not ask for that. But in a true, it was a justice issue. This lady must follow me. Nobody is taking care of her. She has a hope to take care of. She has her own issues. She has her own interests. Why won't you compensate her as my employer? I am entitled to an aid. The only differential is that this aid is so specialized that she must be my spouse. Did I answer or?
Okay, but you have paid some allowance. Since you joined the
disability allowance, which has persons with the disability allowance, which is now 20,000 shillings, is not supposed to take care of that kind of things.
Yes.
No. So that one is an allowance which takes care of basics. Like if I wanted to take a taxi because of my disability, I would pay for that. If Mwangi was not there or my driver was not there and I'm not able to drive, I could hire a driver, etc. It is not, there's a differential between that allowance, which is payable to everybody who is registered with the council and employed by the government or the judiciary, and the issue of aid. If you are not able to see, we would be able to get you somebody who walks you around to your place of work, to your home, and this person would have to be taken care of by your employer. It is the same situation I have. I am not able to live alone. I require somebody who must live with me. Minus that, I'll be dead in the next 3 days. So what happens? You are moving them out of their jurisdiction. They are home. So if you do, please take care of that, because it's part of the employment contract. That is my argument.
Okay.
And I'm saying very, very succinctly that if it is a Chuka matter, where I have a home, if it is a Nairobi matter, where I have a home, I would never touch a cent on that ground.
Okay. So if we appoint you, God willing, my Lord, as Chief Justice, but we don't give you Mangi, your driver, and your personal aide, you will transfer the office of the Chief Justice to Chuka.
I am not saying that is what I'm going to do. What I am saying is that if I'm Chief Justice and in Nairobi, the issue of the aid would evaporate entirely. It would only arise if we are moving out of my station to Nanyuki to check on one or two small things, Kisumu, name it, etc., because she would accompany me and be entitled to that which goes with that. But the aid, the employment status, nothing, because she has nothing to lose.
Okay. And lastly, my Lord, this is a small matter. I've also seen another issue which you have been constantly raising is the issue of the security. And from what I saw, you wanted the judiciary to provide security for your Ngata Rongai home, from again in Nyeri where you are working, maybe in Chuka where you also reside sometimes. So do you want the judiciary also to provide security for your 3 places of abode? If we, as you are writing also, this is one of the documents I saw, you have been writing about that to the CRJ. I
am not sure of that one, yes. But I remember I wrote on security sometimes around 2016, 2017. What had happened is that when we left for Kericho, we left our boy in the house. At the period of seeking security, the young man decided to go solo. He decided to go to hire a place for himself. So we sought security here, and we were even requested to do quarters for these people, and we did. I cannot remember the precise year. It must have been either 2017 or 2016, most likely 2017. But no security came to assist us at Ongata Rongai. So what I did was my public relations with my boy. And 1 year down the line, the place was vacant entirely. For 1 year, nobody guarded it. I thank God for that, for the security which was, divine. So the young man has gotten back. I would not require any security. If you look at my history, I am not very fanciful of issues of security. I can walk anywhere, even as Chief Justice. I have not offended anybody. I have not taken anything from anybody. If you throw a stone to me, you can only be an aggressor. That's my theory of life. I am very, very simple. Simplicity is a hallmark of my life. I have never requested for any security for Chuka. If anybody tells you that, if it is in my writing, let me look at that. I have never requested any security for Nyeri. I have never requested for any security for Kericho. I have never requested for any security for Eldoret. The few months that I lived there, about 2 years, security is not my fancy. Even as Chief Justice, it will not be an issue to me. You might want to force me into it. The government might want to force me into it, but that one we would have to negotiate. I am not insecure whatsoever.
Thank you very much, Judge, and I wish you well.
Thank you, sir.
Honorable Judge, just a small clarification about the card, because you said you just renewed it. There's a new card now. Is that, am I right?
I do not have a new card.
Or is the same one?
I've never had time to go and, I have a renewal of this card.
Okay.
Yes, but I was warned about it by those who are experiencing this scheme.
Thank you, Honorable Judge. I will now request Commissioner Judge Majaja to take you through some questions also. Judge?
Thank you, Chair. Good morning, my Lord.
Good morning, sir. Good morning, my Lord.
Yes, I'll follow up some of the issues that have been raised by my colleagues who have preceded me. The Honorable, the Deputy Chief Justice quoted to you a quote by Ronald Dawkins, one of the leading jurisprudence, about there being no gaps in the law. I want to just give you a situation, and maybe you'll enlighten us on what you do. A couple, Mary and Peter, let's call them Mary and Peter, are in a relationship. And at some point, the relationship breaks down. Peter, one night, goes into Mary's house and rapes her. Then she conceives. And when she realizes she's pregnant, she goes into a deep depression and decides to have an abortion. At about the same time as Peter is charged with rape, he's leaving the court and he's knocked down by a motor vehicle. And unfortunately, he's paralyzed, neck down. When he hears that Mary wants to have an abortion, he comes before you sitting as a judge to restrain her from having an abortion. Applying constitutional principles under the Bill of Rights, how would you attempt to resolve this issue? Maybe you will tell us briefly.
We have Article 26, the right to life. This one entitles everybody to life. So the attempt by Mary to procure an abortion for the baby or the fetus would be an issue or an obligation, an affront to Article 26, and this would not be a constitutional issue. The right to life is absolute and is an entitlement to every other person. The fetus or the intended baby has that right to life, and therefore should be it should be safeguarded so that we have a natural birth and the baby lives its life. What are the rights of Peter in this matter? Good enough, there was some misunderstanding between Peter and Mary. This is a product of a rape. Does he have any right over that? He does.
And what about the fact that Mary, first of all, she has undergone physical trauma. She has undergone mental trauma as a result of this particular incident. And she says, look, and the doctors have said, if she has this child, she will never be the same. In fact, we will have to take her to Mathare. Is that a proper consideration?
It is a proper consideration on medical grounds, on the On examination or verification by a proper, a qualified medical practitioner, we can, the right to abortion is dissipates.
So it is possible that she can have that abortion?
She can have it.
But
if
what
there are
about
issues
Peter?
which are threatening her life?
Okay.
And insofar as Peter is concerned, if there's a threat to life, to the life of to the life of Mary, and or a threat to her medical position, which I mean deteriorates this life to.
So if Peter is telling you, look, I'm the firstborn in the family, I'm the only son of my father, I cannot have any other children because I'm paralyzed neck down, and let her have this child, I will take care of the child, my parents are willing. Would that change your position?
It would not change my position, because these rights must be looked at consecutively. In the sense that, firstly, from the evidence or the facts of the case that you've given us, the most critical person here is Mary. Mary has suffered psychologically on this matter as a consequence of these events, and if we sustain the pregnancy, she might lose so badly that we may not even be able to recognize her. She has human rights insofar as her life and the enjoyment of it is concerned.
Okay, thank you. Thank you for that answer. I think I'll move on to the next. You have brought us, in your writing samples, you gave us 5 writing samples. One, your dissertation, which I must commend you, under the tutelage of Professor Okoth Ogendo.
Thank God.
Yes. Lucky to have been guided by him. Then you have 4 cases and an article. In your dissertation, which is about, it talks about constitutional dispensation in Kenya, the politics of the constitution and the constitution-making process.
Yes.
And I think what we are going through right now is really, this becomes an important topic right now as we are trying to go through the constitution amendment process. And in your paper, you set out 2 hypotheses. The first one is that Kenya is at a crossroads, and you are talking about that particular time. Is at a crossroads.
2005.
Yes, 2005. And you were saying that Kenya is at a crossroads and suffers a constitutional crisis due to past abuse of the constitutional practice by the ruling elite in the entrenchment of parochial self-interests. And 2, that the current constitutional crisis is a consequence of lack of legitimacy arising out of reluctance of the ruling class to incorporate participation of the people of Kenya with a view to accommodating their views and interests in the new constitutional dispensation.
Yes, sir.
When you become the Chief Justice, one of the things you may have to deal with is amendments to the constitutions that affect the judiciary. If you are writing this dissertation in reference to what the proposed amendments are to this constitution, what would be your conclusion?
If we are to make amendments to the constitution touching on the judiciary, our constitution is very, very clear. The issue of public participation must be heard before laws, policies, etc., are heard in this country. And it is basically a right that we include everybody in the decision making and in our policies and in the way we run government. So if we would have to have constitutional amendments which touch on the judiciary, then the judiciary must be involved. Kenya in entirety must be involved, because primarily the judiciary is the property of Kenya. If we are not involved, if Kenya is not involved, we are as a most immediate stakeholder with the people of Kenya, then it becomes unconstitutional, and we would put a case against those who are in charge of the process.
What I want you, my lord,
please,
is you have come in and now you have found the amendments in place.
Yes, sir.
You are part of the KMJ, and we have made our position very clear.
Yes, sir.
We think that these amendments are an affront to the independence of the judiciary. In your first address to the judges, to the magistrates, and to the public, given those amendments, what would you tell the public?
I would tell the public that, one, the staff of the judiciary are not happy with the proposed amendments to the Constitution.
No, they've already taken place. You are now the Chief Justice. The amendments are here. How are you assuring us, the JSC, the judiciary, the public, that in fact we are independent?
I'll assure my members of staff and the JSC, because I'll be the chair of the JSC, that we shall take immediate steps to renegotiate the amendments which relate to the judiciary. Because if the amendments are there and it is like final, we cannot close that. Conciliation does not end. We'd have to, if they are not there, if they are offensive to our functions, we will not close there. We will not say that that is enough. We will not say that we are beaten.
Okay.
We would still push it and raise it.
Okay.
If we get to a deadlock and they are not, it is not done, we leave it at that. We are not going to fist cuff.
Okay, thank you very much for the answer. One of the important areas you will deal with as President of the Supreme Court is the presidential election petition. And I'm sure as you came through this interview process, you familiarized yourself with the jurisprudence, the decisions.
Yes, sir.
And there is a decision that came from the East Africa Court of Justice, Martha Wangari Karua versus Attorney General. You are aware of it?
I have, I know it from the general public, the press.
Have you read it?
I have not read it.
Have you read the cases that led to that decision?
I have not. I relied on the material which was distributed to us some 2-3 years ago, the 2013 elections.
So have you read about the election petitions, the issues about jurisdiction?
Yes, I have, sufficiently.
Sufficiently?
Yes.
So the proposed amendment, intends to make the Court of Appeal the final court in respect of election petitions. In your view, is that a good thing or a bad thing?
That is a very, very good thing. I have been through some write-ups by people outside the judiciary and even inside the judiciary. I've read your write-up on that book on elections. I've read Chief Justice Maraga's. I've almost virtually gone through that book. And issues are arising on the jurisdiction of the Supreme Court insofar as election petitions are concerned.
So what is the issue about right now in terms of the jurisdiction of the Supreme Court in election petition? Where does this jurisdiction come from?
The jurisdiction of the Supreme Court in this matter, in the matter of elections, arises out of Article 163(4), where the issue of interpretation and application of the Constitution comes in. And the alternative issue, which...
So what is the... Yes, they said that it's an issue of interpretation and application. But what do the critics say about that approach?
The critics are saying this, and they have raised 4 points. Muthomi Thiankoru, who was involved in the Munya 1 and 2 cases, has written a very beautiful article.
Yes, so what are these points? Just tell us the points.
It says, 1, there are amendments to the Constitution, to laws. 2013 amendments did not touch on the Supreme Court. The amendments which touched on elections in 2013 to the law were for the High Court and the Court of Appeal. That's a first pointer that the Parliament did not have any issues, did not envisage a situation that, would not have wanted a situation that the Supreme Court becomes an arbiter in election petitions. That is the first pointer. The second one is the capacity of the Supreme Court. There are 7 judges. We have 67 senators, 47 governors. We have 390 MPs, 1459 MCAs. Would any sensible Parliament have anticipated that or provided that in the Constitution, so not the Parliament, but the Constitution drafters, would they have anticipated a situation that the Supreme Court is able to deal with any leftovers, because leftovers are the appeals over these matters, and deal with it?
The third point? The third point?
The third one is decisions of the Supreme Court itself before 2013. The decisions of the Supreme Court pre-election pointed out that this is a memento court, which only comes out at moments of constitutional constitutional interpretation, or they call it a constitutional moment. That is when we rise up and answer to this.
And
so if that be the case, then why would it have to shift immediately after the election, so that every other matter which is in the Court of Appeal, etc., would have to get to the Supreme Court? And lastly, Muthomi Thiankoru argues that any looking at the Constitution of Kenya 2010 does not indicate, there's no indication whatsoever that it intended that the Supreme Court becomes a final appellate court in election petitions. If you read the Constitution.
So if the amendment does not go through, what position would you take?
As the President of the Supreme Court
yes.
of Kenya, as the Chief Justice of the Republic of Kenya, this is an issue of public controversy. The jurisdiction of the Supreme Court, and particularly relating to election petitions. What would I do? Firstly, call our people, the Supreme Court itself.
Let's put it this way, because you don't discuss, you don't decide cases outside live cases.
Yes.
The court has said we have jurisdiction.
Yes.
What is the reverse point? You would say, if you decide that the court has no jurisdiction, in what instances then would matters of elections come to the court? Because you can say, if the court had not said, elections petitions do not have matters of interpretation and application of the Constitution, in what other way would election petitions reach the Supreme Court?
In my own thinking, supposition, and from what I've read, firstly, I would consult widely, particularly amongst the judges of the Supreme Court. so that we come up with our position on the matter. After coming up with our position on the matter, we would go to other stakeholders, those who bring in these arguments and they thrash it out, so that we come up with a concrete position which would act. I am warned that I would not go and bulldoze the judges of the Supreme Court into any position insofar as
yes,
the matter.
it is true you would not bulldoze anyone, but now we are having a discussion. Say, before you come in, the court says an election petition is not a matter of interpretation and application. In what other way would an election petition come to the Supreme Court other than application and interpretation of the Constitution?
I would be very, very, very vague at personal level.
No, not at personal level. You are the judge.
I'm the Chief Justice.
Yes.
We have the judges sitting and deciding on what to allow in and what not to allow in.
Yes. Precisely that.
In that kind of a circumstance, we would have to scrutinize the matters for constitutionality, because it has been argued that if you wanted to raise this matter and enlarge it, every other activities of our lives are constitutional matters.
Okay, I will leave that for you to digest.
Thank you.
The next point I want to take you through is what my colleague Commissioner Warsame touched on. He talks about your driver. He raised the issue about your drivers. You have explained it. But there's another concern which there is a case here. First of all, you are the Teachers Service Commission.
Yes, 5 years and 70 days.
5 years and 70 days. And you were relieved of your duties there.
Yes.
And you went to court.
I did.
And the court vindicated your
all the time.
Yes, vindicated your position. So, in one of your judgments, this is the case of Professor Misia Manuguti Kadenyi and Masai Mara.
Yeah, the Masai Mara University case.
And this is, it's not anything to do with what you did. It's just I want to put to you a situation which, in that decision, and this is what you said. On this, I wish to rely and take credence on the authority of DK Njagi Marete versus Teacher Service Commission, 2013 Ikelar, where my good friend and brother, Rika J, very ably interrogated this term, and you were talking about termination and retirement, and came out as follows, and then he stated the law.
True.
Now, as a judge, wouldn't this kind of statement worry you that this is you're quoting your own case?
One.
Two, you're saying, my good friend and brother Rika J, a case which you succeeded. Wouldn't that worry you?
Good enough. It's a question of expression. One, when I quoted the matter because throughout our jurisprudence in the court in the last 8 years, or any other jurisprudence, I have never had occasion to find anybody who had that succinct and a very good definition of what retirement on public interest is.
Okay.
So it's a matter which fascinated me. In fact, I would give him 1,000%, not 90 or 100. 1,000%. It was beautiful and nice. Okay. On the other issue, we were here in 2011 and 2012, and I learned from the JESC then when we came for the interviews for appointment, the issue of language and talking softly, and I can't remember the term they use. Is it a hard language? I can't remember. But whatever it is.
Yes.
One. I am a student of literature, and I believe in expression.
Yes.
The
point is, before we go on, the point is, if the Teacher Service Commission were reading this judgment,
yes,
okay, you fought them in court.
Correct.
Now you are referring to the judge as my good friend and brother. What is the perception they would have?
One, a good friend. Mm-hmm. There's no possibility. You know, you are my very good friend, a good commissioner. We work together. We are in the same station. We are in the same court, the High Court and the Equal State. We are in the same. We are equals. We interrogate when we find occasion, like in the colloquiums, or when we meet in the streets, or in the corridors of the course, etc. I have no enemies whatsoever.
No. The point I'm making is not that you have no enemies, you have friends. But you know, for a third party, this is Teacher Service Commission, they have been in litigation with you. Then in a judgment, you're quoting, you say, judge my good friend and brother. Don't you think that's an issue which you ought to reflect on?
It could be an issue if you are a simpleton. This is English we are speaking, not the language of the people of Chuka. Even in the language of the people of Chuka, it will be the same. We are saying I have done some descriptive, a reference to, that's what I feel about him. Okay. It has nothing whatsoever to do with what he gave me. In that judgment, he clearly tells everybody, the whole world, that in that period that he was dealing with the matter, none of us, Judge Onyango, the principal judge, was the prosecutor. He prosecuted that matter for the...
Okay, thank you for that explanation. I'm satisfied. So I'll just go back to the last issue. In your earlier discussion, and you laid a lot of emphasis on that, you talked about, you really emphasized your relationship with staff, making staff happy, motivated, and being friendly. In this case of Collins Odumba, it was a case for contempt, isn't it?
Yes.
And the accused there was a member of staff.
No doubt.
Was a member of staff.
Yes.
Now, one of the complaints I have had, and this has been mentioned to me, is that the staff accuse you of being high-handed and heavy-handed. High-handed and heavy-handed. So this was a case where, and if I may just read for you, you say, on the morning of 27th, we were treated to a now commonplace spectacle during proceedings in court. In the middle of the first phase, there were loud, continuous noises heard from outside the courtroom. It was clear that this was a chat between two persons, and the volume and continuity of that noise forced the court to stop its proceedings, as this was not possible or practical. So there was noise in the court, isn't it?
Yes, on the corridors.
On the corridors, and you were unable to proceed.
Correct.
You then went and inquired, who is this making noise? Sent your clerk, find this person.
Bring him in.
Bring him in. Okay. A lot of things happened between, and he was finally charged with contempt. In fact, you said on 30th, this was on 27th, you realized the accused on 30th, this is from your own writing, on 30th May 2016, the accused, who I now realized was a court staff or officer, was brought to court at around 11 hours. 100. What I want to ask you is this. We know contempt is a very serious issue.
No doubt.
Yes. And in fact, you recognize that in your decision.
Yes.
But this is a member of staff.
Yes.
Is a member of staff.
Yes.
Surely, weren't there mechanisms within that station you could use to deal with this particular issue?
If you read the ruling, clearly, you'll appreciate that this was not a one-day matter. This matter had continued for well over 6 months. We had raised issues of people making noise in the corridors, day in, day out, etc., etc., etc. And We had even the chief magistrate, now Judge Ongondo, had taken steps, plus my dear Mr. Ndoruri had taken steps to fight this menace, but it would not go away. For a long, long time, we have this issue, and it is not going away. For a long, long time, we have, the cells down there, and there's noise, and it is refusing to go away. We cannot sustain this. So on this day, we have the noise. People are chatting in the corridors, and the court is continuing, and we call for the officer. We call for the persons who are making the noise. One is brought in. In fact, there were 2 members of staff. One is brought in. The other one says nothing. I am not heeding to that call. What choices did we have? What I did was stop the court and defer proceedings and deal with the matter. How did I deal with it? I got the person arrested and brought it to court. When he was brought to court, he was so panicky, etc., and I said, put him in. We have no time. We can deal with him on a different date, on a Monday. We resumed the court.
Okay.
That is circumstances under which we dealt with that matter.
Okay.
The nuisance had been continuous for a long time, and we suspected that it could even have been deliberate and political. Okay. Otherwise, how are we able to deal with noise day in, day out, 1 week, 2 weeks, 3 weeks, etc.?
In fact,
those are the circumstances in which we found ourselves, and we had to be firm. High-handedness and firmness are 2 different things. I have never boxed any of my officers. In fact, my officers are very, very happy with me. Where you get this kind of reports, good commissioner, I would not know. But when you get that kind of report in the future, even when I am Chief Justice, get that person.
So at the end of the day, would you now you're the Chief Justice tomorrow, maybe you're the Chief Justice tomorrow, are you telling staff that in fact the criminal law will be brought to bear to them for any infraction, that they should fear you because you're the Chief Justice who resorts to the criminal law in order to resolve problems in administration? Is that something you want to tell them, to reassure them?
That is not the message. This was an exceptional case and a last resort. If we had not taken that kind of step, administration had been there. We have a DR, we have a chief magistrate,
in fact,
we have a presiding judge, and this issue had been, they had handled these matters, and they were not coming there was no solution. Particularly when the officer one officer comes to court and sits there with us so that we interrogate the issue of noise.
Okay,
the other
Judge.
one doesn't, and refuses flatly.
Yes.
How would you deal with that?
In fact, in your judgment, you say this issue has this is your own words, reported to the judicial officer in charge of the station, but to no avail. So you had reported to the station.
Yes.
And you even asked, who is in charge here? The chief administrative officer, Rate CEO of Judicial Law Courts, is the senior principal magistrate, one, George Ongondo, that is now our colleague in the Superior Court. What tale of expedient court administration does this portray? What are our levels of leadership in this sector? One thing I want to ask you, were you a member of the LMT in Kericho?
I was.
You were. Was this issue raised?
It died with the prosecution or the litigation of that matter.
No, prior to the prosecution, was it raised?
It never featured as a matter for discussion in the LMT.
Yes, it never. So you were aggrieved many times that this is an issue of noise. You attended the LMT, never raised it. thought it was serious enough, started contempt proceedings before yourself, and then in your own judgment, you indict the leadership of Kericho. So what I'm just asking, should the staff, judicial officers, heads of station have faith in you as the leader to lead this judiciary?
My answer is loud and very, very clear. Everybody is entitled to their feelings on any matter. We cannot take away that right. It is indivisible and a human right. The staff of the judiciary would have to have their own assessment, have their own feelings about me, etc., etc., etc. I have my position, and I will assure you, Commissioner and my Lord, that we cannot lead without firmness. You will not get anywhere. You will not get any results. You have to be firm in what you do so as to be able to establish, to get results, to establish your policy, to establish your work ethics, your standards.
Okay, thank you very much, my Lord, and wish you well.
Thank you.
Okay, thank you very much, Honorable Judge. We will have a short break. But before we do that, Honorable Judge, we must observe the constitutional requirement regarding diversity. So which is your county? Is it Meru?
No, I'm not from Meru. I never was from Meru. In that great Meru, we were just sojourners.
Okay.
And peripheral.
All right.
I come from Tharaka Nithi.
Tharaka Nithi?
Yes.
Thank you. And ethnicity, Judge?
I am Chuka.
Chuka.
Yes.
Thank you very much. And then there's a request, Your Honor, that the card that you have, we would like to see it, just to compare it with the card with Judge Wasame, so the CRJ will pick it from you, Your Honor. And we will have 10 minutes break. We come back at 11:20.
Thank you. Good chair.
Thank you. So, Commissioners, we can take a break for 10 minutes. Thank you.
How do we do it?
Tonight on KBC Channel 1.
Without the acclamation,
Without their blessings, no good deed can ever be successful.
Dad now belongs to the priests.
The throne of Magad is waiting for you. The mother wasn't from a royal family. She was the daughter of a physician only. I am trying to protect your honor here, and you are speaking ill about my mother.
You are staining my mother's character!
Next on.
Yapo mambo manne ambayo Muislamu anapata kunufaika nayo ndani ya mwezi mtukufu wa Ramadhani. Mtume sallallahu alaihi wa alihi wasallam aliwaonesha maswahaba zake namna ambavyo kwamba Ramadhani yao inastahili kuwa. Qad dhakkaratna sawmana wa salatana.
Next on.
Whoa, easy. Did you do anything tonight? Umesemaga leo ni kujitawala. Leo ni siku yetu. Ninakaaji, utajili.
Unakaa poa na hiyo jacket ya wenyewe. You're in as deep as I am.
This time you're seriously going down.
I don't know about you, Glenn, but I'm not going to jail for any reason whatsoever.
Neither am I.
So either you let me in, or tell Tiffany I need to see her right now.
Come on. Nini inaendelea?
Next on.
Mimi talipa. Usio na wasiwasi. Mimi ndio nimejitolea. Hata wewe ukitaka kunywa. Mwanamume akipenda, huwa na furaha na nguvu. Na hii barua ni yangu, nataka unisomee. Na kama niko na uchawi. Unasemaje barua sasa?
I'm so excited to be doing Cover Girl looks with Christine Kuria. And
I feel like now I'm the real, real deal musician. Yeah, I feel pretty. You see, I feel like.
But you always look pretty. You have your signature hairstyle that we love so much.
Yeah.
And when I was working on this look today, I just thought, let me give you something different, something that you're not used to, because you always have your natural hair. So this time I thought, okay, fine, why don't we play with wigs?
Yeah. Oh, I've never worn a wig. I don't know. Yeah, it's my first time. So I don't know, wigs look funny on my... I don't know what you did to this one. It just looks so... I'm sure people won't even recognize me. Hi, this is Masi Masika.
Oh, yes.
Yeah.
Award-winning, gospel singer.
No, really feel good, different, totally different.
And I also chose colors for you that were very different from what you wear, because I was just scrolling through your social media and I'm thinking, Masi doesn't wear...
Black, white, maybe red, and then white again. I don't know, I never looked at this color as a color. As in, as a color for me, I would say like, hii color ni ya Wakamba, na hii color seems good.
No, it's beautiful.
But yeah, I'm so amazed.
Yeah, I chose this color for you. I actually got the inspiration from Lupita Nyong'o, and I thought you would definitely look nice with this color. So what's the future like now for your brand?
The future, I'm going more worship. I'm working on a live project, which is live worship. So
nice.
I'm believing God to reach the world through music. Amen.
And you know what?
Yeah.
I think you're missing something in your music. You are missing me as your backup singer.
No. What I am missing is art director extraordinaire. My God, you're amazing.
Thank you, darling.
See, kukutafutia
Kunishosha.
Who has made me look like this? Really, it's just amazing, the gift that you have.
Thank you.
So you're not going to back me up. I'll be calling you like every day. No, from today, you're my cousin.
Can I audition first so you can hear? Because I have other gifts.
I don't.
As we continue continue the journey. So we're going to go have the photo shoot right now.
Yeah.
But I'm glad to have this sit down with you. So you guys will watch how the other transformations are.
One day receiving a phone call for this amazing 2-day project, and headed up for a meeting, met up with Mercy Masika and Christine, came up with a very amazing 2-day shoot script. Our concept was nice. So the first theme that we're looking for was actually something to do with music. We wanted to put her into an atmosphere of music and instruments and lots of beautiful vibe. And we literally came about a concept of having a white piano. So it wasn't that easy, but we had to put our minds together, think about, where we're going to do this, where we're going to look for that particular place. And we found a very amazing music store in Sarit Center where we would put Mercy Masika there with an amazing long dress. And it was blue, I think turquoise blue, something like that, but that was nice. And yeah, Christine did an amazing job on doing, the creative director. And that was our day one, a beautiful day well spent.
Nichukue, nifunze, nataka kusoma kwa shule yako. Soma Biblia. Nichukue, nifunze, nataka kusoma kwa shule yako.
As you heard, Songbird Mercy Masika on Cover Girl Looks with Christine Kuria.
More about Mercy's new look. Now we are bringing out the model in Mercy Masika. Mercy has this beautiful side that not a lot of people have ever seen it. But I'm so happy that Christine and Zaf saw it and brought it out.
Hey, looking forward to more Cover Girl Looks with Christine Kuria.
Tonight on KBC Channel 1. Without their permission, without their blessings, no good deed can ever be successful.
That now belongs to the priest.
The throne of Magad is waiting for you. The mother wasn't from a royal family. She was the daughter of a physician only. I am trying to protect your honor here, and you are speaking ill about my mother.
You are staining my mother's character!
Next on.
Hapo mambo manne ambayo Muislamu anapata kunufaika nayo ndani ya mwezi mtukufu wa Ramadhani. Mtume sallallahu alaihi wa alihi wasallam aliwaonesha maswahaba zake namna ambavyo kwamba Ramadhani yao inastahili kuwa.
Next on.
Go easy. Did you do anything to it? Umesemanga leo ni kujitawala. Leo ni siku yetu. Ninakaaje? Utajili?
Unakaa poa na hiyo jaketi ya wenyewe. You're in as deep as I am.
This time you're seriously going down.
I don't know about you, Glenn, but I'm not going to jail for any reason whatsoever.
Neither am I.
So either you let me in, or tell Tiffany I need to see her right now.
Come on. Nini inaendelea hapa?
Blaka blaka, mi nimepoteza bongo. Blaka blaka, mi nimepoteza bongo.
Food, drinks, and music are the cornerstone of every culture. Today more than ever, people appreciate their culture and share their culture proudly. Unganisha Festival brings together different cultures and takes into account the positive aura that Kenyan cultures exudes.
Unganisha Festival has been created by two entities. The first one is called the Evolution Art Hub, which is an art hub composing of leaders who use arts for leadership, for social change. And we also have the Mbogi Connection, which is a band, a music band, composing of these beautiful gentlemen who do music. So the two entities are the ones who have been working together. And so we've been garnering people individually, like just the people whom we know, to reach people whom we don't know. So that's how we've done it. But also we've collaborated with the museum itself, because it's been posting like the event on Facebook and all their social media entities. So they've also been helping us to garner the people who are here.
Unganisha Festival is something we birthed in the beginning of the year, which is about changing our neighborhoods for the better. We understand that we don't have the power to change the whole world, but if I plant a tree outside my house, then I've taught my children something. So we decided to begin with planting trees in different counties, where we go and do it with artists specifically. For example, we started in Kiambu County, saving Ondiri Swamp, which is the second deepest underground lake in Africa. So we planted the trees, 141 trees with the artists, did a drum cafe, taught them and shared about the fact that without trees, we have no drums. Yeah, we cannot hear that sound of the drums without the trees. So we've been planting trees, bringing people together for social responsibility. That is Unganisha. Yeah, and doing it here at the museum is a place where there is a lot of culture, a lot of history about Kenya, a lot of stories about even our future. So it's just the perfect place to embrace this and share this with the community.
Unganisha Festival is about uniting cultures, and we're using drums as a way to talk about cultures, because different cultures had different way of expressing themselves through music, and part of the music was drums. So we have a showcase that is going to happen here from around 3, where we have different bands or different groups that draw inspiration from different cultures that are going to come together and just share what they have.
Culture enthusiasts listen to authentic African songs as original as they could get. The most important thing, though, was the message that was being conveyed.
The reception has been amazing. The people have been really welcoming of everything that we have. We don't have as much as we would want to have, but the little that we have, people have been really enjoying. Yesterday we did a lot of dancing, a lot of jamming and watching acrobats, and even just going around the museum. And I think everyone loved it. We all loved how the experience was.
Everyone who enjoys culture, enjoys learning new things, everyone is invited, from kids to old people, from young people, anyone from any walk of life is welcome to take part in Unganisha.
Coming together as the youth, first of all. Second, as African youth who feel we are African inside out. Coming together to share different cultures like this, where even the vendors are selling handmade crafts made here in Kenya. We've even collaborated with the Village Link Up, which is a group that brings black people from the diaspora to come and experience, to have a village experience of Kenya. And Unganisha Festival has been part of their schedule yesterday, today, and we feel blessed to be able to, provide a conducive environment for the people of today to learn about our history, about our knowledge.
The Maasai culture was outstanding, and most, if not all, the enthusiasts had a thing or two from the cultures.
There are ornaments you cannot just wear anywhere, and there are ornaments you can do anywhere. Like the way I am, I can go to any occasion for as long as it's a casual occasion. There are others that we do on, they are single, they are just singles. Mostly they do official, you can do an official occasion with the beads. And also it depends, and there are brides beads. They are the ones attire mainly for brides or in a very, very special occasion about the culture.
Being the first edition, it was a step of faith for the crew behind it, but it turned out just fine.
For me specifically, the fact that this dream is coming to life is just a dream come true. We've been able to, this is our second day and I'm so excited about it. And also the fact that different people from different spaces and walks of life are coming together to enjoy and partake in this and in different cultures is just beautiful in itself.
For this time, the end game was to dare to step out and to do this. And I think we already have achieved that. We've stepped out with a zero budget, literally, and being able to do this. So that was our end, our end game, to believe on ourselves and say, you know what, we can have a dream and we can bring it to pass. Yeah. So, and I think we actually have achieved it.
Ubongo ni ulimi mtima, kwangu akili mzima, tena halisi, bangili pingu, uchumi ndimu, na nani anachungwa. Kwa pati, ka sisi ni part, ni hadithi, mi sifikiri. Ninatimka mi nikofiri, ninatamka mi ni minabi, ninatimka mi nikofiri, ninatamka mi ni minabi. Blaka mi nimepoteza bongo.
Now, and what I noted in the same case, of course, you also made reference to your personal case, where you also referred to your colleague judge as my friend and brother. I'll come to that later.
Please do.
But when it came to the kind of awards that you made, I couldn't follow, and I'm asking this because I need to understand your jurisprudential leadership if you become the Honorable Chief Justice. Because one of the things that you did is that this was, I think he must have been the Deputy Registrar Administration in the university.
Yes.
Now, who had been terminated.
Yes, sir.
Now, you started by saying, of course, you reinstated him, you ordered that he be reinstated. But one of the things that I found I couldn't understand, but you could explain to me, is that the date when you issued the judgment, you said that I hereby order that the petitioner reports back to work tomorrow, the 1st February 2018 at 8:00 hours. You know, basically
Yes.
saying tomorrow by 8.
I appreciate.
You are back in the office.
Yes.
Now, which I was wondering that whereas of course you'd be able to grant that kind of an order, whether as a judge you don't see any practical difficulties in that, in not granting at least some reasonable time even as you are granting these rights, balancing it with some reasonableness. Because you'd imagine if somebody has been away for over 2 years, you know, the employer would even require probably to put in a desk, arrange some administrative measures to make it practical for this order to be effected. What could inform your decision to be so drastic as not to even grant that reasonable time?
I don't know whether you want a very direct question. I can give you a background.
Yeah, but not too long, so that in the interest of time, but you have your day, that's all right?
Yes, I have accused myself of being the judge in that court who is all too free on reinstatement. Having said that, with my issue in my reasoning in mind that employment in Kenya is like a matter of life or death. Whenever you can get back to work, please get back to work. Two, the immediate date. In this case, we have established a case of unlawful termination of employment. That is ugly enough. You've been out of work for so long. Another very ugly situation. You've gotten judgment in your favor. The practicability of, giving you time to return to work, to me, would not make a lot of sense, because the employer is there, he has offended you, he has transgressed your rights, he has made you suffer for no good reason. What is this so critical situation, which would be worse than what you have suffered, that would require that we give you 2 months to resume work, etc., etc. I have never thought that it is impractical. I've always thought that it is immediate, and that is what I have done in all my cases of reinstatement. I have never considered that I am being offensive to the employer. If the employer finds that he is not ready or etc., etc., I have returned your employee. Deal with the situation. That is a domestic matter. The judge has done his work. And to me, that makes a lot of sense. If I am faulted by other quarters, I am agreeable.
Then in the same decision, you went ahead and said the respondent be and is hereby ordered to meet and pay the respondent's salaries and allowances owing but unpaid during his suspension, which is all right. So basically you're compensating the petitioner for the time that you found that the termination was unlawful. So you are reinstating them, kind of like putting them back to the same position they were before termination.
Yes,
but which is fine. But my problem again now, which I couldn't understand, of course I'm not the judge here, just need to understand your reasoning. You go ahead again and say you're also awarding 6 months' salary as compensation for unlawful termination of employment. So you are not only giving the salary during that time, plus all the allowances, so you are reinstating them to that position, but you're also adding another burden of another compensation on top of the compensation you've already awarded. I'm not really getting what is the reasoning behind that and the fairness in it, the justice in the matter. Could you kindly just expound on the jurisprudence behind that?
The issue of a 12 months compensation, which must not necessarily be 12 months. 12 months is the limit. You could do a month, you could do half a month, you could do 3, 4, 5, 6, etc., etc. And Section 49, 1C of the Employment Act is not in entirety the total compensation available to a case of unlawful termination of employment. The judge has the discretion to look for other remedies which are available and which have been prayed for to offer. And this will depend on the circumstances of the case. The judge exercises his discretion depending on the circumstances of the case. By the time you do the matter and finalize, you've gotten the gist of the matter, you've gotten the involvement of the parties, etc., etc. That is what dictates what you offer the aggrieved party. And in the circumstances of that case, we are compensating unlawful termination differently from any other issues of compensation that may have arisen in the circumstances.
Yeah, that's all right.
That is allowed.
Yeah, Judge, but it's only that, again, the discretion must be exercised, should not be exercised whimsically. And again, you see, you already compensate the person. But I don't want to make it an argument, I just need to understand your jurisprudence. But now, you've reinstated the person, which is fine. You say they be paid all their salaries and allowances, which again is fine, I don't have an issue with that. But now again you are saying a permanent injunction be and is hereby issued restraining the respondents from commencing any process towards replacement of or replacing the petitioner in the position of Deputy Registrar Administration. Now, if they're already back in the position and you've compensated them, but you are saying that there should, basically what you essentially are saying is that there should not be any process towards replacement. So if this person misbehaves again, it means then that the hands of the employer are tied. They can never start any process. So again, what is the reasoning around that?
Thank you, good counsel and Commissioner. I relied on the historicity of that matter, the background and the data available, the evidence in the matter. What did I hear? What did I know? Etc. etc. The environment was so hostile that we had to safeguard the position of the employee when he goes back to work for various reasons which are very, very clear, that that was a very, very hostile affair. And two, the issues which they were fighting were not issues which were industrial. All evidence will tell you that it is personal. So when it is personal and you can see it so clearly, you may not be able to declare it or say it, etc., etc. What you do is issue as much safeguards as are possible to the employee. The employee and the employer are not equal. This is an interplay of labor and capital. Capital is always superior. So you safeguard you safeguard labor depending on the circumstances. You safeguard the capital, or you remedy their situation depending on the circumstances. In that, under those circumstances, and knowing the matter the way I did, I was convinced that that gentleman required, the claimant required security in his employment.
Yeah, but you see, Honorable Judge, when you are telling an employer that he should never touch this person for as long as they're an employee again.
Oh, thank you.
Basically, you're tying. But let's move to the next.
I could answer that very briefly.
Yeah, please go ahead, Judge.
If you choose.
Yeah, please go ahead, Honorable Judge.
That was not permanent in that sense. In fact, when he resumed employment on day 3, if he missed, they would restart the process. That was supposed to deal with that situation, the situation we were adjudicating, not anymore.
Yeah, but you see, the way your order was framed had the opposite effect. That's the problem I have. And that's why because I'm asking you jurisprudential questions, because you'll be the leader of jurisprudence in the institution. So that's why I'm asking that question. But now, let's test your decisions, because I had to, again, now do a bit of research. Because this matter of Professor Misia Mangut Kadenyi, the one you asked by my honorable colleague, now I went ahead and actually noted that it's a matter that was a subject now of the Court of Appeal. It didn't end just with your court. And now what I noted is that, for instance, the award that you had given in this Professor Kadenyi case, apparently what you had done is that you had awarded compensation, you had picked salary, which you awarded against the employer, which was not supported by any evidence at all. The evidence was based on the evidence that had been given to you was showing a monthly salary of 333,640, but you picked instead 658,112. In fact, the court said, we have carefully gone through the judgment of the trial court, and there's no indication at all where the monthly salary of Kenya shillings 658,112 is taken from. There is therefore merit in the submission by the appellants, and this figure is unsupported by the evidence. And we therefore set aside the learned judge's finding, the monthly salary of 658,112, and substitute therefore with a monthly salary of Kenya shillings 333,640. So you can see a problem whereby you are probably making a decision based on other considerations, probably emotions, and I can see you keep, in all these decisions, you keep quoting your personal case against TSC, which again, in this case, you are being accused even by the appellant, saying that you seem to be relying more on your personal experience with the National Teacher Service Commission, and there seems to be anger and, which is because of probably you are feeling that you are mistreated, you are now transferring it when you are now deciding decisions. So, wouldn't you consider this to be a serious indictment even by the Court of Appeal regarding how you are making decisions of a mandatory nature against employers and supported by evidence? I don't know what would be your... consideration to that, Honorable
On
Judge?
the first issue, the issue of the amount which was multiplied as a compensatory figure, the 629. Section 49(1)(c) of the Employment Act covers that. Section 49(1)(c) talks about gross salary, not net salary. The employment law does not know net salary, because when we are compensating you for unlawful termination of employment, we go by the law, and the law provides that we use the gross salary. So what a judge, on finding of a situation of unlawful termination of employment, would look for on the pleadings is all the itemization of dues. I was paid 4,000 shillings as a basic salary. I was paid 1,000 shillings as a house allowance. I was paid 500 shillings for transport allowance. That is what you add up, and that is what I did to get to a figure of 629, including the car allowance, which was, if I remember right, 129,000 shillings. So you add all that, you must accumulate all that to get what we call the gross salary. And that is what now, in your discretion, 1 month, 2 months, 12 months, 10, etc., etc., you use as a multiplier effect to get the figure. The Court of Appeal, we may not be able to correlate it. It binds us insofar as that matter is concerned.
Yeah.
But going back to, to ourselves, we would always want to ask ourselves, which is the earlier? Is it the Court of Appeal and its findings in the professor's matter, or Kisirkoi's matter, or the Employment Act? A big question.
Yeah,
I have answered your questions. If I haven't, I could
well,
continue.
The principles of stare decisis bind you. This is the Court of Appeal. Now, again, then, my Lord, again, you see, in Samson Ole Kisirko, you made that order that the employee reports the following day. And what I noted is that in, again, Professor Misia Kadenyi's case, you did the same thing. Ordered that, report tomorrow. So in the Court of Appeal, this is what they had to say about that issue. We wish to state that in instances where the court is satisfied that an order of reinstatement is deserved, it is not prudent to direct that a claimant reports back to office within a day from the date of a court's decision. Such a drastic order is likely to present considerable implementation challenges to an employer. In our view, a reasonable period, depending on the circumstances of each case, ought to be given for the reinstatement to be effected. So you can see when the Court of Appeal is saying that is too drastic, there has to be reasonableness. And you see, the reason why I'm asking this is because you'll be our Chief Justice if you become one. Now, the issue of reasonableness now starts arising in your decision-making process. I don't know whether that makes you change your mind regarding those kind of drastic orders that you keep making, that, I'm issuing an order, I want it implemented immediately without considering the challenges that would arise from the implementation. Not just in the decisions, but even in your day-to-day decisions that you could make here as our Chief Justice.
Well, thank you, good Commissioner. We are open to learning. That is one, first and foremost. But like I said earlier, that is what I have practiced throughout my career, 10 to 9 years in that court. Nobody has raised an issue on that in the past. The matter you are referring to was not an ordinary matter. There were other, side issues relating to the matter. As the Chief Justice, we would not like to do anything which hurts anybody, even as judges of the Employment Court. I would never have imagined that when I tell somebody to go back to work the following day, there would be an issue. Because employment is contracted. The employer could go back the following day and is given a week's leave. In any event, he's been away for so long. The employer could go back the following day, and then another different arrangement is made. All those factors come into my mind when I said that. The agency I created not because I want to, to make it impossible for anybody, not because I want to punish anybody. I want to, it's an indication of agency. It's an indication of seriousness insofar as, labor relations is concerned at the workplace. I am telling everybody that good enough, you are secure when you harmonize your relationship with your employees. When you don't do that and you deal A, B, C, and D, what we shall do is we shall tell them to return. And not because we want to be offensive, but because it is their right. But primarily, I think the whole matter is open to the employer and the employee to deal with that aspect. And if we don't have impossible situations, because we are human, when it becomes an impossible situation, there's no employee who takes charge of an industry. So if he's told by the employer now, you can come back in 2 weeks, 3 weeks, etc., that would be okay. That would be good practice. You will not insist that it just sticks there and it stays there and gets the fruits of immediate reinstatement.
Okay, Honorable Judge, just 2 more points on that decision.
Please.
That we move to something else.
Yeah.
Again, you see in the same decision of a prof. Now, the evidence was very clear that the position of Deputy Vice Chancellor, Academic Research and Student Affairs had already been abolished. But that notwithstanding, you still went ahead and said that I'm reinstating to this position. Now, again, I'm not able to understand why you would insist on reinstating somebody to a position that no longer exists. And in fact, to that effect, the Court of Appeal again said, considering that the position to which the respondent had been appointed had been abolished, we think that it was not an appropriate case to order reinstatement. Balancing the interests of the parties tilted in favor of not ordering the reinstatement, we therefore allow this ground of appeal. So why would they take for the Court of Appeal to be the one now to see that it doesn't make any practical sense at all to order a reinstatement of somebody to a position that does not exist? So again, I'm not understanding the reasoning, around that.
If you get to the background of the matter, you appreciate that that was not a matter industrial relations. The issue was not industrial relations. The issue was personality. You versus somebody else. The Vice Chancellor versus her deputy, etc. And it was not even more personal. It was strictly a personal matter.
Yeah, but
so when it comes to me, and I take that evidence, you say that the place, the position has been abolished. That is your evidence. The other one says that no, the position is not abolished, and if it is, it was not done in good faith. So where does that leave us? When we get a situation like that one, we have a over-reinstatement in that kind of circumstances, we have the most obvious choice. That one of getting back to a position similar to, getting reinstated to a position similar to what you have. But looking at the historicis of that matter, I thought that we should not encourage personalization of industrial relations, of employment issues or employment contracts. Let her return to that office in the same position. The balance belongs to them. The Court of Appeal thinks
agree with you, but you have to always remember that you have to remain a judge based on the evidence, the facts, the law. And you see, this is a case where there was an opportunity for either reinstating to that position or the position of the professor to continue teaching. You reinstated both. The first one was okay, even the Court of Appeal agreed that the one of the professor, that's fine. But this other position, because you can't say abolished teaching, so that's fine. But you reinstate someone to a position that does not exist. I mean, don't you think then that you're putting, the employer in a situation that they can't actually be able to comply, making orders that are in vain,
I am saying that there was evidence wholly on the situation on the ground. There was evidence to the extent that this matter was not so much employment or industrial relations. It was a matter which was, personal. The Vice Chancellor and the Deputy Vice Chancellor.
Okay.
etc.
Yeah.
And that is why I dealt with it that way.
All right, we leave it at that.
The Court of Appeal has come its own style.
Yeah.
It has taught us one or two things.
Yeah.
I had other options, which I chose not to take for various reasons. I get it.
Yeah. Then this issue of keeping on quoting your case was also submitted on, extensively. It was found to be, whereas it's a matter of your choice, but not tidy, as was also observed in a passing. But now let's leave the cases now. Let's discuss now you as an individual, so that if you come here with us, be with us, we can see whether you can be able to do the job. Now, you asked about the question of collegiality in the Supreme Court, where it would be now the president of the Supreme Court. I would want to understand, like, for instance, if the disagreement among the judges there, and you'll be now the president, and I'm talking about disagreement, not about personal disagreements. I'm talking about disagreements on decisions. Now, I would want to understand, again, not in so many words, how you'd want to, which way you'd want to go in terms of managing it. And I'm asking this because, not because of our Supreme Court, because I took interest in some matter in the Supreme Court of US, small versus Memphis, light gas and water, that is the case, where the Supreme Court declined to take over to take an appeal which sought to review a famous case of 1977, which would have reversed a precedent that had been established in the US. But two of the judges disagreed, with the refusal by the other judges, specifically Neil Gorsuch and Samuel Alito. And they actually went public, wrote, a decision totally disagreeing with their colleagues and all that, and went public. And of course, the other judges were quite unhappy with that kind of with that line of action. How would you deal with a situation like that, and what would be your preference in managing a situation like that?
This is an experience I may not have. It's an experience I am going into immediately when I become Chief Justice of the Republic of Kenya. So how do you manage that? At our induction course many years ago at the JCI, we were taught elaborately the subject of collegiality by one of the commissioners here, the Honorable Attorney General of the Republic of Kenya. And this simply means creating brotherhood. Judges are limited in decision making. I mean, there's independence in the decision making. But my understanding of collective decisions, like the ones of the, big bench decisions, is that these are negotiated. There is a conference, there's a conferencing, and after conferencing, they get to level 1, maybe level 2, agree, and if there are any dissents, the dissents also take their place. So, in the circumstances of that kind of situation, however hard the matter is, we, the judges of the Supreme Court, have a duty to deliver justice or to make determinations in all matters, regardless of their intensity or difficulty. We cannot just come out and resign and tell Kenya, no, this one is beyond ourselves. So you see to them.
Okay, so you'd agree with me that experience in managing, even a bench. You said you've never been in a situation whereby you've sat even with colleagues in one bench. I think that's what you said, that also is it's necessary to have that kind of experience, which probably you know.
When we get to the Court of Appeals, to the Supreme Court, I'll be one among his equals.
All right.
There are many judges there who have vast experience in these matters, vast experience at the Court of Appeal, vast experience at the High Court. So there's nothing we lack. It's just a question of teamwork. You can, get off the chair over the Supreme Court in a session where we are doing the conference and hand over to somebody else who takes charge and guides everybody and leads and teaches. In fact, a colloquium is an issue of teaching, exchanging ideas. Sorry, not a colloquium, but a conference. Is a teaching and exchanging and sharing differential, merging differential, etc., so that you are able to create a consensus. And that is where we are. The issue of being Chief Justice and Chairman is just peripheral. This is a team of equals. And we must always recognize that there are two types of seniority insofar as the legal profession is concerned. The seniority based on the date of admission to the role of advocates, seniority based on the date of appointment as a judge, the date of entering that role. So those must be taken into account. But overall, knowledge, expertise, experience, goodness, cleverness, and what have you are not an issue of possession. They are an issue of knowledge. Knowledge is basically knowledge. You know or you don't.
My Lord, I was referring to the experience.
Honorable Judge, maybe you can be addressing the commissioner asking the question with respect. It's good to address the commissioner asking the question first.
I was referring to the experience. See, the High Court judges, sometimes you find that a bench has been impaneled, so they manage that. Same thing also in the Court of Appeal, of course, they deal with benches, and Supreme Court also, they sit, and many of them. That's what I was referring to. But now, again, I'm wondering, you said that when you were asked one of the questions, I think it's when you were asked about leadership, and you said that you've not sat in any big office, and you actually talked about having risen up to, I think, senior state counsel, and then you referred to being a senior, I think, legal officer or something at the TSC, then you became a judge in industrial court. Now, so I'm wondering, if we give you again this position of the Chief Justice, which is quite senior, where you are responsible for for a lot of resources, a lot of issues, is an arm of government with many responsibilities. Now, I don't know what you do to convince me that the learning curve wouldn't be a challenge, because we can't take chances. It's a position. You see, there's a position that there's also very high expectations from Kenyans, the members of the public. Now, I'm just wondering, as the Judicial Service Commission, how would I, for instance, as a commissioner, account to Kenyans that I've given to my Lord, yet, the burden of proof on his part that he is equal to capacity, not based on what he's telling me that he'll do, but based on his past, that he can be able to prove that he's equal to the task. How would I be able to account to Kenyans? I'm asking this with tremendous respect, not to demean what you've done before, but I'm just saying responsibilities versus what you've done and the office. How do you convince me so that I can be able to give you marks with that in mind?
In the first parliament, 1963, when we got independence, most of our cabinet ministers were less than 30. They were politicians. We had not been, we had not ruled ourselves whatsoever, but we walked through. Mzee Jomo Kenyatta was a president. He has not been a president whatsoever. He was just an activist, a politician, a freedom fighter, but we walked through. What we are saying is that to gauge what I'm capable of doing as a Chief Justice, look at what I did in Sharia House in 1.5 years between 1985, 1st of August, and January 1987. Gauge that, look at it, etc. How did I relate? How did I mean, performance, etc. Whom did I lead? Whom didn't I lead? Because even when you get people from, people, your clients coming in and working happy, and you do a job and you get results, there must be a sizable amount of leadership. We have not been in these places or in big office because nobody gave us an opportunity. You cannot hang us for that. Look at my personality, if you are able to. I don't know, that will be difficult for you as a commissioners. My personality, where have I been? Go to my village if you can at Chuka. Look at what I do. Do I own a cow or two, and how do I feed them, etc. Leadership is not an issue of office. And if that is not answering enough, learning does not take centuries. It is just a question of if we landed into that office today, would be able to sit there. Two, you are working with a team. I must not be ICT. I must not be HR. But we have people there who are HR. If I find them inadequate, I'll be able to bring expertise. So you, a leader, just sits there and implements a policy and shows the way. I went to the KIA for a course a long time ago in my TSC days, and we were taught about the difference between a leader and a manager. This is the difference. A leader thinks, states, and lives. A manager is left by to implement. So if you have the idea, the implementation is not an issue for the leader. You have the idea and you say it. What we will do as Chief Justice would not outrightly abandon management. You'd have to combine the two and be on the lookout. But we are saying that you cannot do everything. I am not a teacher, but all the schools around here would get taught if I was in charge of them, because I would get teachers and good teachers to do that. So you incorporate and you apply whatever resources, human resources you have to be able to get what you want. You lead.
Now,
and others follow.
My Lord, now you said, again I'm picking this from what you said. And
please.
I only have 3 more questions. That after you came back from the political seat that you attempted to get, you started legal practice, which lasted for 11 months. I'm just quoting you verbatim.
Please.
11 months, and then you decided to go back to employment at a Teacher Service Commission.
Yes.
Now, I'm just trying to understand what made the law firm not last beyond 11 months. Nothing wrong with that, but I just want my understanding so that I can see how to place you in terms of.
A very simple answer. I left the Sharia house to go for NITHI. NITHI was disastrous. I realized that I did not have any future. I was not a politician. I would not cope with it. So I came back to Nairobi to pursue my career, my profession. In the absence of anything else, I opened an office. I have always known that I am not a practitioner. Legal practice, private legal practice, hands off. That is not my line. There are so many other things I can do in law, with law, but not a successful legal practice. I'm not your personality. I am myself. I have my limitations. I have my gifts. Private legal practice is not one of them. That is why you realize that after my hurried departure from the TSC, I go to Ongata Rongai and sit there and start a practice as a pioneer counsel in that place. 3 years down the line, 2 years down the line, I began teaching. Because for me, teaching is more of myself than a legal practice. In fact, if I had continued, I would have abandoned the legal practice altogether, because that is not myself. That is not my gift. Those are not the areas where I score and go to precisely where I score. 2, all this time I realized that I am a public servant. That is why I sit here today. That is who I am, and that is the best. If you wanted to get the best result in me, public service.
Yeah, but you see, again, now my worry is that we could give you now the position of Chief Justice, and you are unable to, being a judge is one thing, but being a Chief Justice with all these many responsibilities is a different thing altogether. It's a different ballgame. So, again, I would be worried that perhaps, you may not be able to manage that position. I keep reminding you that for us, whoever we appoint, we must be able to look in the eye in a Kenyan and say, this is why, So wouldn't that be one of the reasons probably that could create some doubts in our mind that perhaps we could give you that 11 months later you're not able to manage? And that time, and you see the removal process is a different thing altogether.
No. I don't see it that way.
Mm-hmm.
One, I don't see the link between, a Chief Justice and a private legal practice. Good, you relate with the practitioners up there, but you're not practicing yourself. You know how it is done. The only dilemma is that you cannot do it on your own. It is not your line. You may not be interested. You may not even know. You cannot be hung for that. This is a public office, Chief Justice of the Republic of Kenya, which, any able leader would be able to do, particularly if you are fast, like I am. You'll be able to sit there and get everything connected. You have everybody that you require. And if you don't have, you could always bring them in so that you use them to get what you want. You are the leader. Legal practice, private legal practice, and this office, this grandiose office of Chief Justice of the Republic of Kenya, to me, not.
Okay. Second last question.
Please do.
Now, you see, if you become the Chief Justice, you'll be also the chair of this commission, JSC.
Yes.
You would actually come here and now be a primus inter pares. You'll be the first among equals. Now, I'm just wondering again, because, managing us, you can say we are all from different, we are representing different constituencies. But you have to put us together, and we are one cohesive commission, chairing us, and all that. And of course, it's not an easy task. Eh?
It will never be easy.
Now, tell me, what is it that you think you have that, gives you that ability? Because, you see, this commission, of course, it has immense responsibilities vis-a-vis the institution of the judiciary. Because again, I'm looking at your CV, I'm looking at what you've done, and I'm still not seeing what is it that can be able to put you in that primary position of being able to make the commission function in a way that it's able to undertake its duties. And as you're answering that, this is the same commission, without getting into many details, you've already had so many issues with it, which you're aware of, and them that are still outstanding. So I'm still wondering, how would that work? Because, see, again, you can see the Court of Appeal is talking about tidiness. Even as you are making decisions, as you are making certain considerations, I'm just wondering how tidy will that be? That our chair now, will the chair come and start dealing with his issues first with us in the commission, or shall we get down with the business of making sure the commission is able to deliver on its obligations both to the judiciary and the Republic of Kenya?
The issue of ability is not an issue whatsoever. The Judicial Service Commission has its obligations, which are dictated by law and practice. Who is in charge or not in charge would not make a difference. In this sense, if we are committed to what we must do to fulfill our mandate as the Judicial Service Commission of the Republic of Kenya, and our roles are explicit, what it would require is that we move on to create work plans for implementation and acquisition of the Ed Resort. I would lead in that. But I would believe that I'm leading 12, 11 others who are committed, as knowledgeable, who have the goodwill. So that where I sleep, you raise me up. Where you sleep, I raise you up. So it is not this work. If the entirety of the Judicial Service Commission that we have today left, in a week we would have another Judicial Service Commission, and there would be continuity. The issue is not, where you have been. The issue is, are you able? I believe I am very, very able. I have a proven record. Go to Chuka, you look around, you see what I have done. Even, my coffee shop, I will tell you, this person is able. etc. I have answered. How satisfactory the answer is,
so my last
another question.
My Lord,
sorry, there is if you allow me, good Commissioner, there is the second limb of the question, my issues with the Commission. Will you allow me to answer that?
Yes, go ahead. Please,
go ahead.
My Lord.
Thank you. My issues with the Commission are not personal. My issues with the Commission are as such issues with the Commission. The Commission would have the ability to deal with all those issues independently and freely, even if I was a chair. I'll just get out. That is what we do in the church or in any other meeting. If you are conflicted, or it is a matter which conflicts you, you take off, and the others make a decision. Good enough, yes. 9 complaints. I do not generate complaints. Complaints are managed by the Commission, and we shall not take that away from them. So even as a Chief Justice, as late as the other day, we knew and we had, it was public knowledge that the Chief Justice had complaints which the JESC would even ask him to answer for consideration. None of us is immune. And I thank God because Kenyans are at liberty to raise these issues. And we shall not take that right away, because that is what our independence is all about. We are accountable to them. They can raise 1,000 issues against me. I'll answer. If I fall, I'm indicted, good enough.
I'm satisfied with that.
So my issues do not
Yeah.
have nothing to do with
I'm all
what the
right with that,
Commission
my
will
Lord.
do.
My final question.
Please do.
You see, the hard reality, regardless of what we may think, whoever is the Chief Justice must be somebody who must attract the respect of the peers. And of course, even as they enter and they take that position, Kenyans can say yes, the person must come up with that, it must be somebody who people can say, yes, that's a person who is befitting of the office. I'm not saying you don't, but do you think you have that? That's all. That's my last question.
Thank you, and thank you again. If you are looking for yes, it has been said very loudly, and I know that, and I'm not cheating myself. I can mark myself 90%. Kenyans have loudly said that is a man, the man of the moment, in the airwaves. I'm not talking about communication Commission of Kenya. No, I'm not talking about radio. I'm not talking about TV. But if you feel the air around Kenya today, it is very, very, very clear. We have. I said that this is a man. Did you see the 2 reviews I had on the newspapers? The one on the Standard immediately after Easter, and the one on Sunday last. That is what I presume is the voice of Kenya.
Okay, thank you very much, my Lord. I wish you well.
Thank you, and welcome.
Thank you very much, Your Honor. I will now request Commissioner AG to ask you questions.
Thank you, Honorable Chair. My Lord, Justice Marete, I would not wish to belabor you with too many questions because many of which I would have asked have already been put to you and you've answered them. But just to follow up on what Honorable Commissioner Macharia has just been discussing. You seek this office against a backdrop of 35 odd years of experience. And you have attempted to persuade us that you are indeed the man for the moment. And you have sought to demonstrate that you would be able to learn and learn very quickly. And you said, my Lord, that you would engage the public as well as the judiciary staff, make them happy, motivate them, etc. Would you be pleased to tell us, Your Lordship, which existing organs within the judiciary currently which you would engage to enable you learn quickly and to achieve the mandate of the office? There are various organs existing within the judiciary as we sit here. Which are they and how would you engage them?
One, we have offices and officers. The office of CRJ is very instrumental in the running of this institution. She's the CEO of the institution.
That's one.
The office of the very able Deputy Chief Justice. She's been in that position for long enough to be able to even be Chief Justice herself. It will require hand-by-hand contact. For a year, for a month, 2, 3, 6, 1 year, etc. That collegiality and the cordiality between those three offices is like the issue is resolved. Because through the Honorable, the CRJ of the Republic of the Judiciary of the Republic of Kenya, I'll be able to access all the other human resource which is available through reports, through any other means. The CRJ, the time she has been there, knows the judiciary and its operations throughout, inside out. And being here and available and knowing her personality so well should be a vital asset in helping us walk through this journey. The Deputy Chief Justice is here. The Commission is here in entirety, a big force, Judicial Service Commission. You would even go to the other associations, the independent associations for like the KMJA, the Kenya Women Judges Association. These are institutions and organs which would be able to tell you and give you what you may require in terms of learning and be able to support you as and when you need it. They are your colleagues. You are not their senior. I would be able to work within a class 2 kid today and transact business. Why wouldn't I be able to work with everybody? Inequality, that is my terms of trade. Everybody who deals with me we deal at the same level, at parity. So all this crowd here of senior officers, the JESC, KMJA, the association representing judiciary staff, all those organs, If I wanted to borrow from them, it would be instant. And I believe they would be willing to lend a hand. And there we are. The judicial, this is not personal. The Chief Justice is just there as a figurehead. The whole thing belongs to all of us in equal shares. And Kenya, equally.
What about in relation to the courts, my lord?
The courts and the administration, you know, we have heads. The president of the the Court of Appeal. We have the various, principal judges, the principal judge of the High Court, the principal judge of the Employment and the Labor Relations Court, the presiding judge, or in quotes, the principal judge of the ELC, big consults. Beyond that, you can even go to the individual judges. I'm accessible to virtually, as Chief Justice, virtually everybody. And this place is rich. Do I repeat that? Look at who is sitting besides you. A giant, insofar as performance is concerned. An intellectual par excellence. And there we are. There's nothing we lack whatsoever.
Thank you very much, my lord. Now, you discussed the jurisdiction of the Supreme Court in relation to election petitions. Would you be pleased to tell us, my lord, whether you consider that jurisdiction should be expanded or restricted generally in the Supreme Court, but not in relation to election petitions?
The Supreme Court should be very, very guarded and very guided in the way is the jurisprudence in the way the jurisprudence on election petitions and generally every other matter is concerned. We read from Kenyans or even other scholars outside this country that as at the time of the elections in 2013,
my lord, please, you explained the aspect in relation to election petitions. I should ask you now to deal with the jurisdiction of that court outside the framework of election petitions. Should the jurisdiction of the court be expanded or restricted, and if so, why?
I would not think that it should be expanded because, one, let's look at this, at the basics of your question. The Supreme Court has expressed itself on that, and the ratio decided is to extend that in all these other courts, the High Court, the Court of Appeal, etc., we have competencies which will be able to deal with any matters constitutional. I should even deal with that down to the magistrates' courts. These are professionals who have the capacity and the competency to deal with matters constitutional. That being the case, and looking at the circumstances and the basis of the Supreme Court, I would think the safest thing would be to narrow it, not to expand it, even in these other matters, so that you are restrictive and you are able to guard what you take in and do it very, very well, so that you become a guide. One, you become an authority in the region, and you are able to meet the expectations of those who created the Supreme Court. Because the Supreme Court has got its own historices, and there was that which it was intended to cover. I would implore a very, very conservative and restrictive approach to jurisdiction in the Supreme Court, so that we are able to, one, cope, two, allow everybody else down there, the Court of Appeal. We are talking about a rival jurisdiction. As we speak now, in the out there, I mean, we are talking about a rival jurisdiction, things which are extremely dangerous. Let's allow everybody to do their bit. Let the Supreme Court do what it was intended to do by the drafters of the Constitution through, the people of Kenya.
What was it intended to do, my lord?
Primarily, the Supreme Court was intended to deal with the issue of a presidential election. In fact, if you are lay and, you heard of the Supreme Court in 2011, 2010, etc., post-Constitution, what everybody told us was that that was the most critical matter. But you know that cannot be done forever. The Supreme Court becomes a lead court, and it was intended to be that, lead in terms of jurisprudence, so that you are not doing 1,000 matters. Do 5, 10, 100, and do them so well that anybody looking at them will be say, I was guided on A, B, C, D. The thinking is brilliant. These people had their time in so doing. They were not rushed like we are rushed by backlog, so that you are able to come out clean and guide Kenya on its governance patterns. The framers of the Constitution put it right. Issues of constitutional interpretation, issues of constitutional interpretation and interaction, good enough. But now, when the Supreme Court itself now sits, what does it interpret this to be? And when it does that now conform with the expectations of the drafters of the people of Kenya?
And my lord, how would you then, if that is your belief, what leadership would you offer in that jurisprudential development?
One, the issues which are in contention, the issues which have been raised by the Kenyan public and any other interested party, international, scholars and academia, etc., I would subject that to a public debate. They would be thrashed out, and they would have a policy which is not guiding on the decisions of the Supreme Court. We cannot tie the Supreme Court. As we do it at a public level, the Supreme Court would also be sitting to think. We would create a situation of reflection, a situation of introspection, a situation of consultation and rethinking, so that if we are convinced that there is a problem, we are stifling the other courts, we would deal with that freely and openly. But it would require the Supreme Court on its own to sit and reflect, introspect, and generally see what is available and what is offerable insofar as what we have today is concerned. Very convincing, very able, and a very good jurisdiction, if you ask me. But issues have arisen. If you read any of those matters and opinions and decisions, they are fantastic. They sound good and etc. 1,000%. But now when you come to the ground, other intellectuals are raising issues, and we cannot ignore them. They are part of our stakeholders. They are Kenyans. Quietly, we have issues even which are internal. Like the critique on my decision, the Court of Appeal judgment made very firm interventions on my judgment. This may not be that formal, but we have other areas which may be feeling uncomfortable with what the Supreme Court is dealing with and the extent it is. So we bring everybody on board, we thrash out the issues, we make recommendations and solutions, we hand it over to the Chief Justice, not as a direction. The Chief Justice would take it up and deal with it as a style with his judges at the Court of Appeal. Because the Court of Appeal can only recreate itself. We cannot go there and hammer them into recreation.
Thank you very much, my lord. Let's move on, just a couple of more questions. You've heard this phrase, why hire a lawyer when you can buy a judge? You familiar with that?
Very familiar.
If you do become Chief Justice, what would you do differently to deal with corruption in the judiciary?
One, surveillance. It is one thing to say that you are dealing with the corruption, and that this is a very thorny issue and a very, say, sensitive issue, because whoever would listen to me answer this would pick quarrels with me if they were in that side. Thank God I don't belong there. So, put effective surveillance mechanisms so that we are able to detect these cases. You know, corruption is a very personalized affair. It's not an affair which, is public or publicized. It's like any other very personal, areas of our lives. I don't want to mention them here. So that this two-way matter, unless the Chief Justice and his officers do very strict surveillance on this, and also deal with it very firmly, because we cannot sit here and pretend that we are serving justice when we are doing things under the table. If you are not writing a genuine judgment, then you have no business writing any. You should walk home. So that when these things are influenced by not even corruption, call it bribery, is that cheap? By bribery, you are telling us that we are not in serious business. So the Chief Justice should put his foot forward, should do surveillance and employ any other methodology, including the EACC or any other mechanisms to arrest corruption. The Kenyan public would never be happy like I would offer them if they were still being asked to pay 20, 30, 40 shillings, 1,000, 2 or 5. And it's so unfair, so immoral, that I will not kick anybody, but I will not be amused. I'll do everything possible within my means to eradicate this entirely.
My lord, what mechanisms would you employ to ensure that corruption cases are heard and determined expeditiously, which is not currently the case?
Did we agree that, or did I submit that I would, in the next 3 years, I'd want all my matters determined in 360? Or if you want to increase that, 365 and a quarter days, so that in every 12 months, a matter which has been raised with us is determined. We have an issue with the criminal justice because it is a broad spectrum. We have an issue with corruption cases. Corruption cases and what is hurting the Supreme Court, elections, is a class affair. It's very rare that you find people who are involved in corruption being my brother who does his beans and bananas at home. Not him. It's somebody like me, you and everybody else. And do we call it class? People who are up there, the elite of this society. That is why it becomes very, very difficult to deal with this. But do we have judges in that court? Do we have adequate staff? That is the first question. Are they happy? Have they raised issues why they are not able to deal with these matters? You'd have to get the background material if you've not been there. When you get that, you fix it and insist that these matters are done on time. In fact, on time. And in the first instance, you should not have any matter which takes more than 2 years. The second instance, you are getting to 18 months. The third instance is 12 months, and it is doable. If the prosecutor does not want to do their matter, they can as well keep them or prosecute on their own. The Chief Justice Emeritus, my good senior, David Maraga, always told everybody, bring your evidence, we shall deal with it. If you don't bring your evidence, don't we have mechanisms for dealing with the matters? Because backlog, people bring their matters here and they go to sleep. You bring a corruption case or any other matter which is a criminal, etc., and you go to sleep. I mean, litigation is a business. They are professional litigators. What they litigate, we do not know. I've learned that from those who are in the judiciary earlier than myself, those who have worked in the judiciary have that advantage. My spouse was here for 38 years. She retired the other day as a junior officer. Don't get worried. The Honorable Attorney General. And we know that there is business in litigation. There is business in delaying litigation, etc., etc., etc. If we sit as a combined force of the judiciary, we'll be able to eradicate this, to stumble at and eradicate it.
My Lord, forgive me for interrupting you, but you've been a judge for 8 years. And even if you haven't worked in the corruption court, I assume that you have some knowledge of the workings and the impediments that face the judiciary. You are now Chief Justice. What steps, what practical steps would you take to eradicate some of these problems that you're alluding to?
One, identify the issues, the problems.
The problem is delay in determining cases that touch on corruption.
Get to the court and address the officers who work in that, the judicial officers who work in that court. Get to the court and address the administrators of that court. Get to the court and get their experiences. Why are we not able to deliver? Why do we keep a matter here for 3 years, 5 years, etc., etc.? When you have that, get to set targets, clear targets, which are permissible, acceptable, or doable. You will be able to know from the experience. They'll be able to give you data on what is doable and what is not doable, and why it is not doable. When you have all that knowledge within yourself, you devise strategies which make it work. I know it can work. I know it has improved. I don't want to mention names. I know it has improved, and it is coming out well. It can be done.
Thank you very much.
Honorable the Attorney General.
Last but one question, my Lord.
Please do.
Is the judiciary independent?
The judiciary is independent. I'm very, very happy about that. I've been here for in July it will be 9 years. Nobody whatsoever has wanted to interfere with the matter I was doing. We can feign a lack of judicial independence, or we can be participants in that non-independence. When you create situations which mar or stifle or stumble your independence, like corruption, you are not telling me that you are involved in corruption and then you are also doing an independent, you are independent as a judicial officer. Zero. That is not the reality. The judiciary is important. I am a living independent. I am a living example. Nobody in 10 to 9 years has interfered with my decision making. Look at it all over. Who has come here to hammer anything on the judiciary. What haven't we done? Presidential elections, and they walked free. Very sensitive matters, and walked free. Let us not point at anybody. We are independent. If there is an issue of lack of independence, then we shall say that we are our own worst enemies. We collude to create non-independence. So far as I'm concerned, we approve 1,000%.
What role do you think the other two arms of government should play in protecting the independence of the judiciary, and how would you, as Chief Justice, encourage that?
One, the issue of a constitutional government, starting from the judiciary, going to the executive and the legislature. And a constitutional government which also appreciates constitutionalism. We have had some very good writing by my good friend, the late Professor H.W. Ogendo, Constitutions Without Constitutionalism. That is where we start and end. Because you are singing this, you are doing this. You preach this and take the other. If the other arms of government took constitutionalism seriously, this country would cure within a week. If we all took it upon ourselves to practice what is right, to eradicate impunity, we will not require a week. Do you remember the NAC revolution in 2002, which lasted only 11 days? We were there. We had it. We can have it. With the participation of all the stakeholders, the executive, the legislature, and ourselves. Combine and liberate Kenya. That is what we are called upon. That is why we are paid so heftily by the Kenyan taxpayer. Did I answer?
I'm much obliged, my lord, and that will be all from myself. Thank you very much, Honorable Chair.
Thank you so much. It's been a big pleasure, and always welcome, my senior.
Thank you very much, Your Honor. I would like to ask Commissioner Gishohi to continue the questions.
Thank you, Chair. Good afternoon, Judge.
Good afternoon, sir.
Yes, I will be very brief because most of the questions have been alluded to, but do allow me, if you don't mind, Honorable Judge, just to focus more on the Commission. And I want us to remain with the Commission as much as possible. You have reflected on this period, 2011 to 2016, the foundation, 2016, 2020, 21, sustaining. I want to be very clear. If you get this position as the chairperson of the Commission, just one thing that you'll be able to do or to initiate to deepen, broaden what you asked, what the Honorable Chief Justice previously in those two periods have actually put in place as far as the Commission is concerned.
Insofar as the Commission is concerned, on transformation, I would bring up the Commission to appreciate its position vis-a-vis the judiciary. One of the biggest issues we have today, and it was mentioned on Monday by my good friend Justice Chitembwe, is the issue of management of complaints. That is the elephant in the room. If you ask me, I'll write 1,000 pages or tell you a story for 10 weeks on what it costs, the opportunity cost of answering a complaint.
Complaint.
So what we are saying is let the JSC take a decisive role in dealing with complaints. I don't know whether Commissioner Gishoi, not Gishoi, but the representative for advocate Macharia is here, and
Yes.
I want to use my example.
Yeah.
You want to please allow me that.
Without going through the details about it.
Yes, in 2013, I get a complaint. In 2015, we deal with it, and I am successful. In 2019, the same complainant brings a complaint against 6 of us, 5 in the Employment and Labor Court, 1 in the High Court.
Okay.
And the JESC forwards it to me for answer. That is the issue.
Okay.
What is the capacity of managing these complaints?
Very good, Judge. That's a good complaint. I want you to look at the issues, and it was raised earlier on, that you are the chairperson of the commission, you're the Chief Justice. And I want us to focus on the organs of the commission, organs, not individual offices, organs that you can utilize, that you can be able to touch, that can be able to make those changes. As chairperson of the commission, as Chief Justice, could you share with us those organs within the commission that you can either strengthen or establish or abolish?
I am not versed with the workings of the Judicial Service Commission. I will not score 40% on that one. But I can mention the areas which I would touch, and then maybe it can be linked to the organs, so that when like the issue of complaints, the body behind that one would have to be streamlined.
Two.
The issue on the growing of development would have to be touched on, because this is where our infrastructure is infrastructure and the other materials that we utilize, like the ICT is anchored. We would have to touch that. The issue of human resource.
Good.
It's very, very critical, because without human resource, we are as good as dead. We are not in business. We can have all the courthouses, all the buildings, all the it will not be any business. So those critically are the 3 areas that I would like to touch. Start with.
Let's take human resource, because that is that's very critical. Yes. And you talked about making the staff happy, not to fool around, and you talked about a result-oriented approach. I want us to focus on customer-oriented approach. You have been saying about being happy and the rest. Were you to have the customer-oriented approach to make sure the staff are able to produce in terms of productivity? What will be your targets? What did you do to make sure that you have a very clear strategy on how you are going to motivate your staff?
One, let us agree that staff will require facilities to motivate. Staff will require education, training, because I could as well give you an elephant, but you do not appreciate the value of an elephant, so it is not a serious business. Education and training to be able to understand where we are, what we are doing for them. I will allow staff to have their liberty. In fact, if I became Chief Justice, like I suggested 3 years ago in a colloquium, I would allow every officer of the judiciary in their respective capacities to, if they choose, form trade unions. Why? Because it is easier to deal with something which is organized than to deal with a hazard and amorphous things. Groups. We have quite a number of suits on salaries. We have issues of confrontations between the JESC and the staff, etc. This can only be achieved if we have a structured system for those staff members to deal with us. It would even be time years, and a better way of dealing with it, because we don't have everybody working individually to deal with their matter.
Very good.
Please.
Talking about training and developing the staff, I want you to focus on the role of GTI. And as chairperson of the commission, where would you place GTI? What kind of facilities would you give that institute to make sure that it is able to give the service to the staff and to judicial officers also? GTI.
The JTI, you know, today is not the JTI we had 8 years ago. JTI was big, it was brilliant, and it was very, very good. You'd go there and meet on international, conferences. The JTI, I anticipated even from then, was a JTI which was a complex. I'm not quoting or copying anybody. This is my experience the first time I landed at the JTI. A complex. We do an institution which is self-contained, which is good, which is good to go.
So what has gone wrong?
I would not know. Earlier I said that I'm not an insider, and it was not...
But Judge, you've been here for 9 years.
Is that insider?
Yes, 9 years, long enough. 10 years, kid is going to primary school.
I think we may have to revise our English.
Okay.
Insider means somebody who is actively involved in the administration of the judiciary.
Okay.
I am a judicial officer. I'm inside, yes, but at the periphery.
At the periphery.
Those areas are not mine.
Okay.
But on the JTI, that one, without even from where I am, because it's an institution I love so much. It's a place I value so highly. Firstly, give it the requisite personnel. We had a very good JTI in the reign of the Honorable the Attorney General. We had a very good JTI in the reign of Justice Professor Ngugi.
Okay.
Excellent. It went diddling, I believe, because of finances and maybe administrative issues. I do not know. But
That's
what
enough.
I will do is firstly facilitate competent personnel to deal with the institution. Secondly, deal with it. Have international linkages. The personnel who go there must link it to other international similar institutions or even greater institutions, so that it becomes a benchmark. We can benchmark with them. Infrastructure.
Okay.
We would have to do it well, so that you have been to the KIA. It has changed names. I can't remember. The infrastructure, the KIA. Which is, I've been there twice, thrice, I can't remember, but it's an excellent facility for mobility in government. Government doing its own affairs.
Okay.
JTI should go that direction and even improve on that. Somebody suggested in the interviews that we should own it. There has been a resistance by the owners. That one I know. I'm a friend of the good Professor Ngugi. So when that kind of issue arises, we should not stay there and mourn that, they are resisting. Look for land and start afresh.
Okay, Judge. Let's move on to something else now.
Please.
You're talking about financial independence of judiciary.
Yes.
Lack of funds.
Yes.
You need the funds. The Kenyans pay money, taxes, to fund the judiciary. If you get the position as the chairperson of the commission, do you need the funds from government, from the exchequer? Would you share with us, as the chairperson of the commission, as the head of the other arm of government, what strategies would you put in place to ensure that we get adequate funds? 3 strategies, please. 3.
One, take care of whatever we have from the government of the Republic of Kenya, the Judiciary Fund, establish it, take our share, and claim for more if it is possible. When we have that, we are well anchored. If that, and it is not going to be enough, then we do fundraising. Fundraising is a contact with our friends and other stakeholders so that they assist us in raising funds to do a magnificent JTI, buy some 20 acres of land and get money to do it and raise it in the next 3-4 years.
Those are
doable. Fundraising and donor.
Donor fundraising.
What we have not looked at is, being conservative in a way, prudent and a conservative user of what we have. Government is known for buying this pen for 500 shillings. I started using this pen in my TSC days. I don't remember what it was like, but I know this pen costs 230 shillings. At most 240. If I move to Prestige up here, I'll get it with my 230 and 40. So prudent utilization of what we have.
Okay.
We complain over nothing. We just abuse resources.
Honorable Judge,
please.
You are the chairperson of the commission. You are the head of this arm of government. You are talking about the total budget of judiciary. Yes? And I want to hear from you as a chairperson of the commission. And you know the government cycle. I've seen from you have a lot of years. You have 17 years in AG's office, 5 years in the TSC as a public officer. I mean, how do we find other organs of government? What is the system? What do we do?